move for a directed verdict, I think someone found Wisconsin law which says that if you move for a directed verdict and then you bring and it's denied and
Yeah.
you forward your case in chief, in that case you have no right to appeal it. I don't know why they couldn't move
Yeah,
for it
I
twice
understand
though.
that. I get
I don't
it
know
though.
why
I
couldn't
get
they move for it twice.
no
Like move
that
for
you
That's what
can.
we do
That makes
down here.
Yeah, that no, you can move for it twice. That's exactly right. Like, so if you move for it at the end of the state's case and you lose and you put on your own case now, you can't go back and question that decision again. That makes total logical sense. But you can still at the end of your case, and now that's an appealable issue. Or you can when the jury comes back, and that's an
That's
appealable
weird.
issue. So it
That's
just moves in time when it is. And hello, Legal Bites. How are you this morning? They've
hey.
been waiting for you.
Good. How are you? I know. I was getting caught up with
That's the soap ad for Legal Mindset.
Well, I wasn't thinking that route, but I mean, there you go. I guess there's a market for that too. They're probably. I mean, I've seen some of the chats, some of the people in the chat for Legal Mindset, so there could be some people that would be very interested in that as well.
Can I
Or
talk
just
about
the
something completely
bathroom liquor
different for a minute
caddy.
and bitch at Facebook and YouTube for taking away the dislike button? I know it's
Oh.
completely off topic, but I want to bitch about it.
Well, it's not
So we no
entirely
lo-
off topic, right? Because we're talking about the MSM.
Yeah. We're taking away the dislike button because of dislike bombs. Sure, it has nothing to do with the mainstream media's things being completely ratioed to hell, or YouTube React being ratioed to hell. It's to protect the small creators because YouTube is so well known for protecting the small creators. Don't you know? Okay, we can move back to Rittenhouse if you like. I just wanted to say something about it.
I want to do this. I don't know. Yesterday, I came to a realization about Judge Schrader, and who he reminded me of.
Ooh.
Oh.
And
This is gonna be bad.
someone actually sent it over, and it's exactly correct. So here we go. There he is. There he is. That is it. I cannot shake the image of him being that turtle. Oh my goodness. What
You know
is
what?
this? What is this, Joe? What do you have here?
that made me. That was one of the things that was sent to me. That made me start crying on my with laughter last night. That was somebody picked a good moment, yeah, and they really captured. I want. I will. I should point out that in the comments, someone basically pointed out that we have to change Runkle's names to Logolus. So
Yes, I think that's pretty good for a new channel name,
Logoless.
Logoless.
Oh my gosh.
so I just thought I'd share that with you guys.
Yes,
So.
legal mindsets seems to be the most accurate, I think. So did you guys? Sorry, I had to step away for a minute. Did you guys talk about the that the state will be potentially at least telling us the lesser include or not, yeah, the lesser included list is what was alluded to yesterday, and they should have that finalized today.
What I want to point out, I think is, first of all, if they bring these motions, you're all on the same page with me that it's got to be like one by one charge on each of these on each of these murders, right? I mean, the charges are broken down that way, and I think that if you work backwards in time from what happened, there's an admission from Gage Grosskreutz that it was valid self-defense. That one I think is the easiest slam dunk to get a directed verdict on. You might not get on Rosenbaum, you might not get on Huber, but the assault on Gage Grosskreutz after he admits on the stand that that the gun was not fired until after he aimed his gun at Kyle.
All right. Now we have. No sound. Why is that picking that up? Why is this like this? I mean, I'm 2 feet away from the stupid microphone. Why is it clicking? I was at 200%. Auto adjust had my microphone at 200%. All right, how's this sound? Now I'm going to check out this. How much wood could a woodchuck chuck if a woodchuck could chuck wood? Is a woodchuck chucking wood now? How much wood could a woodchuck chuck if a woodchuck could chuck wood? Hello? 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 Are we back to woodchuck chucking wood? How's this? Alright, let me turn. Hey, will you check my sound? No, I can do that. I mean, I'm doing that on mine. I've got it on back thing. What beeping sound do you hear? Is it still going on?
Hello? This is she.
That didn't work. Alright, what about now? Okay, bye.
The sound is like likelihood at this point, and I think after
Okay, so we have sound problems. What about now? Okay, so I'm trying to find out why I'm having sound issues. I think I just figured it out. Sorry about that. All right, now, and this has been a pain. How's my voice on now? And if I do that, that is so weird. All right. Am I getting anything? All right, so for some reason, my mic was at 200% yesterday. So now I think I know how. Now it should be better. It should be better. If I quit doing that, it'd be awesome, though, wouldn't it? Oh, cool. All right, I gotta get some stuff done. I gotta get some. I've gotta get a dead cat. Let me. Do we not have? Thank you for disliking this. Whoever disliked this, thank you. Oh, Lord Judah. So let me explain what's been going on here. This is I'm using Melon. It's from OBS, and it's the software rendering whatever that gets it up online. I kind of like Melon, but you only get like 4 or 5 hours a month to use it, and then you have to pay. I really like StreamYards. I'm used to it. Well, I got a notification today that I'm running low on time on it. And I'm like, well, I don't want to run low on time on that one. I had the extra time, I thought, to set this up. So I went ahead and set this up. Then my microphone, everything's messed up. Well, I found out I've been on 200% input. And that evidently, that's what the auto mic configuration set it for. What auto mic is supposed to do is has it set at the volume you have it at, which I always have it at 80% input. So your 80%, like when you have highs, it will reduce those highs so it doesn't get, real loud. I'm sorry, guys. I'm still this allergy season, whatever. It's wrecking on me. But instead of doing the auto right, it did auto at 200%. And it's just absolutely, I don't know, it's ridiculous. It's all just so stupid. What YouTube should do is create their own system that you can just, auto upload all this stuff, have the background going, everything. But,
you could
but YouTube doesn't like any of us anymore. I've decided they're I don't know how to say it. Like, I just found out, like, gun content, I think they're going to demonetize all of it. I don't know how far that means. YouTube monetization isn't that big. For instance, like, if you're on your app and you see somebody like this Nick Rakita here, you want to send him, $1, or he'll does super chats. So you send him like $5 and he'll read whatever your question is. When he's got 100,000 viewers live, I've been noticing that a lot of people have started putting stuff up that they're selling. Like, go to www.calrittenhouse, KenoshaKid.com, whatever, and buy a t-shirt. And I mean, that's a cheap advertisement. $5, $10 for get them to read that from 100,000 viewers. But here's the thing. So let's say it's $10. If you do that through your phone on a super chat, Apple takes 30%. So now you get $7. That's $7. YouTube takes like 40%, I think. So what's 40% of 7 is 28. So you're down to like $4, $4.20, $4.20. And then after that, the government takes half. So on $10, the guy sitting here that's doing all the research, doing all the work, putting all their stuff together, buying the equipment, paying for the electricity, paying for the internet, all that stuff, they get $2.10 out of every $10. And that $2.10 has to go to paying for the equipment, paying for this, paying all that other stuff. It's ridiculous, isn't it? Sorry for the deep breath. I'm still looking for a pause button. I need my own personal pause. tell you what, this Melon app does have some cool features, though. I'm not even going on there, am I? Oh, it's still speaking. I didn't know that. I messed up. Am I still on here? Yeah. Okay, so see, now I can't see. I can barely see when I'm speaking. Turn that up a little bit. Okay. Can I see myself? Hello. Yes, it is. Barely working. Maybe I need to brighten my screen. Alright, let's see here. I can't stand this. This is driving me nuts. I'm screwing around with the way my screen looks. Oh, there we go. Okay. What did I just do? This is a really neat program here. All right, there we go. Now I need to find my streaming. There we go. So I'm connecting Twitter to this account. And I can't type and talk at the same time. So, all right. I just got interrupted by the missus, which is always a pleasure.
Blob is the fire extinguisher. I don't know. It's not.
But that doesn't even appear in the other image. You know that
Yeah,
that little
yeah,
white
that's
there's nothing there.
Oh
And
wow,
then
look at
suddenly it
this.
appears over there.
And
On the left
again,
one.
that's why the introduction of this photo evidence should never have been allowed.
The guy on the right, look, his stance looks completely different.
It's actually
wow.
that's another thing that Pasoviak pointed out is that the motion on here is the motion lines are different for these people. Because the image look at how it's changed the blurriness of the original and actually sharpened it up while enlarging. That doesn't make sense.
We've
That's
gone
not
from
how
our
that would.
hands down our side to like in a just
Oh
straight up
wow, look at this. This
side
is
by side pose. I can't tell anything from this photo. I see
Yeah.
no things.
Yeah, the street sign, of course, has significant distortion and artifacting versus the original. Like again, maybe it's not a big deal because if the jury looks at this thing and they see the same thing that we're seeing, but you never want to leave it to the jury to recognize what's obvious because they might not.
Yeah, you don't leave it to anybody.
I think
The
from
original
from
look
the
has
judge's
people over
perspective,
here.
though,
There's
I
no
think
people over here.
when it comes to making out what the picture says or what the picture looks like, that's probably something that he figures is more for the fact finder at the end of the day.
I kept hitting on this yesterday, and I will not let this go. And I think it's reversible error. It is. Tell me if any of you have.
Why
ever
is
heard
sharpened
of
imagery anything in post production
imagery ever being admitted without there being testimony that it fairly and accurately depicts what it purports to portray?
No, I definitely agree. I don't think that they
And
that
no
they
one
met their
testified to
burden.
that. They couldn't
Right.
testify to that. And to
Right.
me, that's reversible. And letting this in is reversible error. If he wants to let in whatever he wants to let in, and even if you want to qualify the most unexpert expert in the history of trials, who's the only expert I've ever heard, which every answer to any question is, I don't know. Well, what happens with this? I don't know. How does it do this? I don't know. I hit click and it blows it up for me. I mean,
did you check the results next to each other? Did you check the final picture
wow,
next
this
to the
is
original
a
picture?
big.
No, I didn't do that.
This is really big.
Exactly. So we have zero basis to believe that this fairly and accurately depicts what it's purporting to portray. That is evidence law 101 inadmissible. That's
This is really big deal they're doing here.
If they convict.
Yeah. I almost wonder, do you guys think that it would have been helpful if Sheriff Busey had actually brought up these two images next to each other in front of the expert, non-expert witness and actually pointed out these differences and said, explain how this shows up, explain how this little white blob down here by Kyle's foot shows up in the left image, but you don't see it in the original image. What is that? What's happening here? How is that not more information that has been added that didn't exist in the prior one? Explain that to me.
Explain how this light becomes this rectangle of light. Explain that to me, sir.
Yeah.
Explain how this Yeti, right, becomes a blurry murder dog. I don't know what these two images even are. Like we can't down here suddenly. Look at this. Oh, here's my favorite. This person. Show me where this person exists in the original image.
Oh yeah.
Yeah. Oh, that's a big one. Oh wow, right there. It's a middle finger. See, so just right there, he's shown where
they're cropped out, I guess, of the bottom. So this is a bigger image. So again, these two things are not the same because this would have to be.
Still don't know where this guy went to.
Here, and it's still not the same. But
I feel embarrassed to offer this as an exhibit on every possible level.
Unless let's just, I just want to make sure that we're clear. Are we sure that the original one is the one on the right and not the one on the left?
I was just gonna say no. I don't know,
because it would make sense to me if the one on the left is the original and the one on the right is the one that crops out everything else.
In which case we're losing detail because the thing that's on the curb no longer exists. So take your pick.
Right.
Yeah, the thing that's on the curb no longer exists. The sign is suddenly got details that were not present before.
Oh man,
the streak.
This is the most amazing thing I've ever
light
seen.
reflection on the car is different. I think they're actually different frames. Personally,
that makes sense, and I'll tell you why. Because if you look at the woman to his right,
wow,
she looks like she's more turned towards the camera on the picture on the left, and more sideways in the picture on the right.
And her shiny shield of radiant brilliance has changed complete direction.
I think it's like 3 milliseconds apart from each other.
Oh, hey, they are. Look at that. Look at the shoulder.
And their emotion, and that's why it's turned.
They're different photos. That's just the greatest news ever.
That's what I believe makes the most sense. This is different. That would explain the whole angles line, which honestly, when Kosobe points those angles, I don't know what the green lines are supposed to mean there either.
On the left, behind the truck, I've got two blurry things that could be people or canisters
or a fence.
Something. And then on the right one, I've only got one of the blurry things.
Yeah, I think these are two different pictures.
that this was allowed to be admitted into evidence is in my opinion, the worst decision that the judge has made in the case.
Yeah, no, there's a lot of bad decisions. This is
Okay, I'm curious what decision you would say that rivals this one from the other than not declaring a mistrial, maybe.
allowing
but,
the legal charge of the illegal possession to go to jury is
Oh, yeah.
up there.
Yeah, that's true. That's true. But this one is, I mean, this is evidence. This is on a murder charge. Like, this is being
That's
used
the whole
as
key.
evidence on a murder charge.
To put
and
him away for
upon
30
inspection-
years. To put him away for 30 years over this random pixelation. There's randomly adding in different color pixels. That's what they're potentially gonna put him away for 30 years to life on.
Yeah.
It's insanity. It's insanity. This poor 17-year-old kid. His life should be hanging in the balance because someone decided they're gonna pull out a crayon and just start photoshopping in whatever pictures are happening in there. And if it's not an individual manipulating intentionally, then it's a computer that's manipulating and trying to guess what pixels should go in there.
And it's really important to note that Binger's argument is that we all use zoom and cropping on our phones. Got it. And Shirfisi pointed out correctly, we're not using those pictures in a murder he said a homicide investigation. That's not what they're being used for. And if your life is on the line,
So on my phone,
you have to have
I've got an
these things
iPhone, right?
It's so unfair.
You can
to the
do
defendant
an optical zoom,
has the
but it's only like
presumption of innocence,
2x. I
who
don't
has
even know
all
if they're
of
up to
these
now in optical
rights
zooms.
to confront their accusers.
And then after that, it goes to
what
a digital
accuser is he
zoom.
confronting?
I
here?
always try to
A
stick
detective
with
who looked
the
at a
optical
video and
zoom.
interpreted it in a particular way. Almost none of the evidence in this trial should.
My whole thing is
be
that
there. None of the
everything
video
that's digital is
should
fake.
actually be in there. But Richards and Shirfisi,
Even though it's all
they
being stored digital and
stipulated the
everything else,
authenticity,
we're just gonna have to
so
go back to
then
film.
It gets to come in, and the question is, I guess, how much of dicks do you want to be on that? But I don't know, man. They've let in a lot of evidence that has no foundation.
Also, one other thing, kind of on a slightly different subject, but I was reviewing the part of when Drew Hernandez was on the stand and getting into the line of questioning about him hiring an attorney. I actually, I was a little tired yesterday. I hadn't yet caught up on sleep yet from the night before. But I guess I wasn't paying as close attention, but I think if I remember quickly from reviewing the video that the judge actually snapped at Binger in front of the jury. I think that may have been the first.
All right, I gotta go check something real quick. I'll be right back.
When he got the objection for relevance, and then Binger started to justify, like, well, there have been a lot of questions about people hiring attorneys, and then he was like, what's the relevance? He actually snapped at him, and I think only after that he let the jury out. I thought that was interesting.
Yeah, the other questionable decision of Schrader yesterday, and this one goes the other way, is his Veterans Day remark.
Yeah.
He's got John Black up there on the witness stand, sitting down, as he does. He has a very professional court demeanor, which is great. And he's sitting there at the witness stand. The jury is in the room, and he says, "Oh, speaking of which, it's Veterans Day. Do we have anyone who's served in here? Anyone on the jury?" And then anybody over here? And John Black, stands up. And I got the impression that he may have been the only veteran in the entire room. And
then he goes and he talks about not just being a veteran, but being a Green Beret, being like a lot of he's got a very impressive resume, 30 years in the military.
And 23 in law enforcement. I mean, the guy's been doing his job, but
no, I definitely agree. He could have Judge Schroeder also could have remarked that it's Veterans Day, Happy Veterans Day, kind of made a note of appreciation for everyone that has served without specifically identifying who in there has served. But
if they had done that in the opposite way, that would go in your motion.
There was a real risk there that one of the jurors was a veteran. I don't know the degree to which they vetted that out or not, but if there was one veteran there, and then those people might, just having been applauded, might now suddenly have undue influence in the jury room.
Yeah.
So that would taint the jury, and that would be another reason to appeal. So fun.
Although, I mean, within the jury room, I mean, someone could easily speak up and say, "Hey, I served for 5 or 10 years or whatever, and I know guns, and what they're
It
saying is
probably
either
doesn't
accurate
help
or
being
not accurate."
primed. It doesn't probably help with reams of applause by the judge. Yeah.
Yeah, it's like I said, I don't think it matters as much because he was a defense witness. And I don't
Yeah.
really care if the state is prejudiced personally. You could not find a lower thing on my list of court reforms that need to be fixed rather than the state being prejudiced by a minuscule amount. But if it was the other way around, I think it would matter a lot more. Lindsay B says, if Kyle is acquitted and Littlebinger wants to retry him, can the DA decline to take it back to court or order Binger not to as well? Well, Binger wouldn't have the decision at all. The DA would have the decision to retry Kyle.
Right.
Binger could maybe recommend it, but the DA has a thing. But if he's acquitted, let's be clear, if he's being precise on legal language, if he's acquitted, they can't bring the charges back.
Because that is double jeopardy.
Yeah, it would only be in the case of a mistrial from a hung jury or a mistrial that's dismissed without prejudice by the judge. One of those two instances where they get another bite at the apple, I learned, was the correct phrase yesterday. Raymond Fire says, I'm confused on this case. I have heard that this is an easy not guilty verdict. Well, under the law, yes. He says, yet it also seems that you guys think that Kyle would get found guilty. From what I can see is if he is found guilty, self-defense in this country is gone. Does anyone want to comment on that?
Well, for me, I think that the risk of him being found not guilty comes from what the jury has seen of the evidence and what the jury, what kind of biases they have beforehand. I mean, because as I have, like, if I were a member of the jury, I know how I think about this evidence as I have seen, as I've been able to analyze it. But I've been able to pay attention to whatever extent, and I don't know what the circumstances are for each individual juror. I like the fact that they are allowed to take notes, though. Not every court allows that, by the way.
No, they don't.
Yeah, it's up to the judge's discretion in Wisconsin in the criminal procedure rules.
Yeah, and I love that because I think that not only does it help for recall, because when you're getting hit with so much information, you can very easily forget something, and it also helps you to pay attention more. But yeah, I mean that's basically that's my thoughts on how he could end up guilty.
Let me ask y'all this. I mean, I think from what I've seen in the news reports or what I've gleaned is that the whole argument that the prosecution, or maybe not so much the prosecution, but the supporters of the prosecution are making, is that because he brought his AR-15 to the car source and all the other places, that he was provoking others. And therefore, if he's provoking others, their argument is that anybody else bringing their gun up, in effect, was acting in self-defense from him. And therefore, him shooting these people could not be self-defense. How do you think that would fly with the jury up there? I mean, in the sense of, from a political standpoint, from just the pressures that you see in the news, and I know they're not watching the news, or at least they're not supposed to, but of course, how could you not know anything about this case when you're being ordeered?
I mean,
oh, go ahead.
Oh, I was just going to say, I can't see how that could possibly be the law, although I'm not a Wisconsin lawyer. But, I mean, juries do weird things. Juries will sometimes convict because they say, I thought he looked shifty.
Yeah.
The prosecution had a real bad case, but he wouldn't look me in the eye, so I wanted to convict, is basically a quote from a jury interview on one case.
Mm-hmm.
You never really know. So whenever something is going to a jury, sure, I think a reasonable jury should acquit this guy, but you don't know if your jury's reasonable or if they're going to do something like, oh, well, the prosecution guy had a nicer suit, so we decided we were going to convict.
I've also heard of a jury looking at a photo of a crime scene and looking at, in the very top corner, there's some sort of piece of what they think is evidence that was not admitted at evidence, at trial, wasn't not evidence at all, but they saw it in there, and they somehow, for some reason, attached some kind of significance to it and just went down a complete rabbit hole that had nothing to do with anything that anyone was talking about at trial. So I've heard of that kind of stuff happening too. So I completely agree. They're wild.
Regardless of what the law of self-defense is, I mean, I think there is a risk that you might have some juror sitting there thinking, well, I mean, Rittenhouse shouldn't have brought his AR-15 to town, and if he hadn't brought his AR-15 to town, nobody would have been coming after him. I'm not saying that is or isn't a good, valid, or a valid, reasonable argument, but I think that's something that any jury, and I think that's something that Richards and the defense team have got to really be concerned about, because
well, that's the whole theory of the case for the left. Yeah, that's the only theory of the case.
Yeah,
that's actually where they should spend a lot of their closing argument, in my opinion, since they have 2.5 hours of closing argument. They can do a 30-minute course on the fact that merely having a gun out is not sufficient provocation to justify someone attacking you. And in fact, there are several people, including Gage Grosskreutz, who had a gun present at that event that night. There is, in Wisconsin, you can open carry. You know this. You have seen guns out on the streets of Kenosha, and no one is randomly attacking those people. That doesn't happen. That is not sufficient to go after, to attack someone. It is not provocation under the law. It is not provocation in common sense. They need to focus on that.
The prosecutor was also advancing sort of as a provocation thing. You knew that putting out those fires would make them angry. You knew that cleaning up that graffiti would make them angry. And I'm just like, if
that was a weird line of argument.
If stopping the city from being on fire is provocation that allows people to attack you, and you're just required to, at that point, sit there and die, like, is that really
the fires is the provocation?
It's the same kind of logic as, you're wearing that dress and that's gonna cause somebody to come up and grape you, right? It's the same exact logic, and no one would accept that today, especially not people coming from the people that tend to be on the side of Kyle Rittenhouse being guilty tend to not allow that kind of line of reasoning, which I agree on any subject. It's not appropriate.
That should be the opening statement, right? Ladies and gentlemen of the jury, imagine, if you will, a young lady, girl, woman, I don't know the term. She's out there.
Female.
She goes to a bar. She's wearing a skirt, and that skirt's a little short, on the shorter side, and she's in a bar with a lot of men, and then they rape her and said she deserved it because the skirt was too enticing. And the skirt's an AR-15.
Yeah,
roasted bomb is the
I don't know about
that
that
is
one.
what the defense needs to do in their opening.
I'm not sure about that one.
I spent a half hour.
I think that there's been enough hard R in this trial without.
No, I spent a half hour on this analogy, and I'll take it one step further. Here's the thing: if you really think about that analogy, which we're standing up for the right that a person can wear whatever they want, whether it's a short skirt or whether it's an AR-15, and that does not entitle someone to feel so triggered that they have a right to attack that person, and then we're going to blame the person who's donning the dress or the AR-15 and say you have no longer have a right to defend yourself. And if you defend yourself and hurt this person who was triggered by what you had on you, in that case you could be guilty of murder. And if anything, the woman in the skirt, and I still 100% think it's unjustifiable for any man to attack a woman, and you're a sick individual if you do.
Yeah.
But what I'm saying is, if anything, the
agree.
woman is trying. She genuinely, we know for sure, is trying to allure men. And even though we know she's trying to allure
maybe
men,
women,
I say anyone. Okay, whatever. But she's trying to allure people with her sexuality and create a hunger, to trigger a hunger in them. Now, I don't think most rapists are triggered by natural sexual hunger. I think they have other crazy, ridiculous
desire
issues.
for power and stuff like that.
Right, and insecurities and all those other things they're trying to overcompensate for. But on some level or another, there is a certain sexuality, and they are
Whoa,
trying
whoa,
to
whoa.
put out their goal is trying to put out this sexuality. And so all the more so when I say a woman has every right and not only may, but must and should and must defend herself from a would-be attacker and with lethal force if necessary. And the left has been screaming about
Well,
this for
according to the
decades.
prosecutor, not if the guy has only kind of has it out but not pointed in your direction yet. And
Hey,
Oh, and if he's got a
Yeah.
smaller gun than you, that
Oh,
Yeah.
you know,
Yeah.
Nice.
But,
Well, I
When his
have, I
gun
have
is
a
too small.
question.
Yeah, nice.
I have a question. How many women are on this jury? Do we know?
It's
yes.
11 and 9, or it was when it started.
11
Is what?
women?
It was 11 women, 9 men when they started it.
But
Okay,
we,
but
and
how
one
many
of
are-
one of each has been dismissed. But we don't know how many are actually on the jury. We don't
Right.
know the actual
They
jurors.
haven't
We
drawn them
just-
lots yet.
You got
Yeah.
at least
Okay.
5 women there. You have at
'Cause
least 5
that's-
women there.
I
makes a powerful argument.
I could see a lot of women sort of subconsciously sort of thinking of that logic
yeah.
during this trial as Binger is kind of putting forward that argument to be like, well, wait a minute, if I go into a bar and I'm wearing something that I'm wearing because I like it, it happens to be attractive, and okay, that's fine, but I like the way that I look in this dress, and that is 100% why I'm wearing this. Like this sort of logic. Anyway,
Yeah.
so
You shouldn't have worn that
I wouldn't
scantily
be
thing on the
surprised
streets
if
of
they would
Kenosha.
independently be a
The
little bit
mean
more
streets
favorable
of
to
Kenosha.
that.
even if you don't want to get into this, like if you look at Top Gear, had that episode where they're driving around a car painted with slogans designed to offend people, and that's free expression. That's free speech. You know, you could drive around, you know, just saying, "Hey, you knew this was a really conservative town that you're driving around in a
That's
truck
right.
with man love painted on the side."
Man
That
love
doesn't
rules
mean that
okay.
that's provocation, and now you should lose self-defense. That's
You know,
Yeah.
Joe, there's one other thought that crossed my mind. You were saying, because I'm going to take this and take your argument and take it even a step further, because I don't know if anybody's ever raised this, but a few years ago, I had a case where a guy was charged with the possession of a gun while he was in a drugs, stop for drugs or whatnot. And in my motion to suppress, I pointed out that because he was between the age of 17 and the age of 45, and he was a male, under federal law, he was a part of the unorganized militia of the United States, pursuant to, here's the statute, got it right
The
here.
Militia Act of 1792, I think.
Yeah, Title 10, U.S. Code, Section 246. And of course, the DA thought that was hilarious, but then he gave me a deal. Point is, I mean, I'm wondering if Richards and them have raised that, if it would be too late for even them to bring it up.
No. I don't want to go there. No, put that
Wait,
in
wait,
the
wait.
jury's head
So
of the militia.
Explain what you're
Kyle's-
trying to say there.
I'll read the
because the
statute to you. Statute says here, subsection A, the militia of the United States, this is federal law, Title 10, Section 246. The militia of the United States consists of all able-bodied males at least 17 years of age, and I believe he was 17 when this happened.
Mm-hmm.
And except as provided in Section 313 of Title 32, under 45 years of age, who are or who have made a declaration of intention to become citizens of the United States, and female citizens of the United States who are members of the National Guard. And so essentially, if you're a guy between the ages of 17 and 45, you are automatically a part of the militia of the United States under federal law. And I think if he had wanted to make that argument in a legal motion or something, he'd probably say, look, I'm the militia of the United States. I have the right to have a gun there whenever there's insurrection happening.
I
New
don't
York
know
State
if
that.
it's in their legal brief, but it was actually raised at oral argument in the unlawful possession portion that 17-year-olds are part of the national militia, and that they use that as sort of instructive on why there's an exception for 16 and 17-year-olds. Or, well, they didn't say 16 and 17-year-olds. They just said 17-year-olds. Why there would be an exception for 17-year-olds built into the unlawful possession of a firearm charge is that they would be members of the national militia. It didn't seem very persuasive to the judge. I don't know if they briefed it other than just it was raised in a very short bit of oral argument at pretrial, I believe. I was either at pretrial or it was done briefly during trial, but like before trial started that day. I can't remember. There's a lot that has happened. And to the chat, we are just waiting on the live stream to start. It is now It is now 10 o'clock Central Time, and it should be starting up any moment. So I have it on the background here.
I want to ask you guys, when they were did they ask Gage why he brought a gun to this thing? Do you remember them crossing?
Yes.
Crossing with that?
Yeah, he said because he believes in the Second Amendment.
Is that what he said?
Yeah.
No, seriously.
Yes. I'm not joking.
So, I mean, the whole thought is, why should he be bringing a weapon to this thing? And there were tons of protesters there. I mean, Binger was on cross, was drilling him. Like, why bring it? Unless you think there's going to be a problem. Unless you think you're creating a problem. Unless you think there's going to be a problem. Why are you bringing it? And the obvious response on argument is, why did anyone bring it? They all had the Zeminski had guns there. Lots of these protesters had guns there. These rioters, looters, arsonists, they all have guns there. Why are any of them bringing it? Are they expecting that there's going to be trouble? It doesn't make any sense, especially if no one else showed up from the other side. Why are they bringing it? You're going into a situation where you have people who have guns, and there's a lot of emotion, a lot of hostility. He's got to be crazy not to bring a gun.
Well, and the other thing is that they never actually apply this to the other side. Like, what was Rosenbaum doing there? The guy who's dropping the hard R is probably not a big Black Lives Matter activist. You know,
Yeah.
I kind of feel like that's an inconsistency as to what he's doing there. So if we're saying, why is Kyle there? Kyle's got a good reason. He's trying to, sort of support the community. But why is Rosenbaum there? Well,
I think
he wants to set some fires.
I think they completely flubbed the Rosenbaum girlfriend cross-exam. I mean, I know they got out of there that he's bipolar, or that she thinks he's bipolar, and that's why he was taking his particular meds. Great. Why didn't he stay at your house? Why didn't he stay at your house? Oh, he couldn't. Why couldn't he stay at your house? Like, because he's your boyfriend, right? He's just coming out of the hospital. Certainly, he needs a place to sleep that night. Was he going to come back to your house? I mean,
she could have said, I didn't have room. She could have made up any BS excuse for that.
Yeah, but that's not what she's planning on saying, because the state had said outside of the realm of the jury that she was going to, or that he couldn't stay there. And
no, I understand that, but she could have made up a thousand other excuses besides the legality of it if she was looking for
I know, but let the judge get it in their mind that the state knows the answer and that their witness lied and that she was probably coached to it. To me, ask the question. That's one of the most frustrating things.
I agree with you.
Ask the questions, because if you get to the hospital, if you get to the mental hospital, if you get to the restraining order, if you then get to ask, oh, did you know about his was this a surprise to you when you were in this domestic violence situation? Has he been violent at other times that you're aware of? Like, you just start going back down the road, because maybe you get all the way to the fact that he raped children. And I mean, that's the prejudice you want. You want to know that this guy's got a history and propensity for violence. And if you can get there through the witness that they've given you for no reason other than to talk about how he was a good boy who brought an empty water bottle to the protest, like, just drill it. And they should have let Huber's great aunt or whatever testify to how he was a good boy and he ran towards the fire that he probably even.
That was a mistake.
Because if they would have let that question go, they could have said, "Was that the fire that he set? Did he set that fire?" Because he was charged.
Then she wasn't there, so she wouldn't know. She wouldn't be able to answer that question.
Did you know that he set fires in the past? That's right. So once she answers that question, Judge, can we approach and talk outside of the jury? I'd like to propose a line of questioning, and then just hammer it home. Those two were big flops.
Yeah, I think that with those two, I'm wondering if the strategy there was to not go too hard on them because of the fact that they're both grieving, and that usually doesn't play well with the jury. So
okay,
that's a justifiable thing.
And there probably was. They probably figured that there's enough evidence in these videos and in the testimony from people that were actually there to show that they were being violent. So you don't really need the propensity. So you don't need to dirty your own hands by knocking on an 85-year-old great aunt.
This is why we have a woman's perspective here. because
I don't know.
she gives us the
Bury him.
What? You sexist,
Here we go.
misogynistic.
I mean, I don't know that we're going.
By the way, I can be here for about another hour, and then I'll be on Eric Hunley's channel, just so you guys know.
Oh, really?
Sweet.
Yeah,
Well, tell Eric I say hi.
I will. I will. I will.
Maybe I can be on both
poor
streams
guy.
at
He's
once.
been
Is
he's
that
been on
a
the
thing?
sidelines this whole week.
Who else is going to be on Eric's channel? Do you know?
It's me and Emily D. Baker.
All right, maybe I'll pop over there for a while.
Tell
He sent me a link also. I was like,
tell Eric
we'll
to
see
send
how
me a
long
link
this
if he hasn't
motions take.
already.
Okay.
Tell him I'm very
or
offended that he didn't invite
DM
me.
him.
Okay, yeah, we'll do.
Yeah, Katie, you want to go? You want to go join on?
Yeah. Britt Cormeyer says we all use Zoom on our phones and know how it works. That is like saying we all have driven cars, so we know how the internal combustion engine works.
Yeah.
Yeah, or the GPS. I mean,
Ooh, I can explain how GPS works.
oh, please don't. I took that math class. David Stern says you can take the victim blaming analogy one further. If a 17-year-old girl attends a concert that's 18 plus, she should not have been there. Same as Kyle accusation, and she is assaulted. Is she at fault for being somewhere she shouldn't be? Of course, it's not her fault. That's good. That's
a
good.
great
right
example.
there.
That's a great example.
Yeah. I mean, just this whole idea.
Hit the
he
Me
shouldn't
Too
have been
people
there.
hit the Me Too people in the crotch.
Well, no, don't do that. If you hit the Me Too people in the crotch, you're getting charged. You don't want to do that. It's very unsafe.
I see what you did there.
Very unsafe. Whew.
Is he looking through a written motion? Maybe that'd be cool.
He's reading something, some concern maybe someone has. Did you guys happen to see the interview with Gage Groskowitz on Good Morning America?
I haven't seen it. I've seen people have they've tweeted me with it, but I haven't actually taken the time to sit down and look
I made
at
it
it.
45 seconds in before I felt like retching, and I was just when he was talking about the fake testimony from Kyle, I was like, "F you, you freaking ham actor, terrible!" Like
The guy who admits lying in about the first 2 minutes of his cross.
The jury's not here, and we're here to talk about instructions and verdicts. And the district attorney has
And to the chat telling me all about the images, we know. I got it.
We got it. We covered it.
multitude of lesser included offenses.
But we appreciate your enthusiasm.
Oh man, he is the turtle. How I
Yes.
can't unsee it.
Especially with that tall chair behind him, it kind of like looks like a shell.
I'm looking at. I'm sorry. I'm looking at their. Sorry.
Oh, and what's the pin today? How's
He doesn't have one on.
So
No jury.
And no flashy
I
suits
have
today.
count
Just
one,
sports
just
coat.
the first degree. I'm sorry, the first degree reckless homicide. I didn't see any lesser included on that. You?
They asked for 1020. Did you get their written request for instructions?
I did.
They asked for 1022. Oh, yeah, there was an email last night. Did you get that?
I did.
Okay, they asked for 1022, which is not the standard for first degree reckless homicide. It's the standard for first degree with a lesser included of second. Okay.
We're not asking for that, but I understand the court might get it.
Okay. Are you objecting to its giving?
Yes.
I want to discuss it briefly, or just impose or argue, object for the record.
I guess I would just object for the record.
Okay. All right, then, I'm not going to decide right now because I just got your filing this morning, which was sent to the clerk in Kenosha. They sent them to me directly. And I know you're not familiar with that procedure, so. And actually, I wish less people had my email right now. But, I think that's probably a common feeling.
He amuses himself.
I will, what I plan to do is to send, at some point tomorrow, I will send you what I expect to deliver as the final instructions and verdicts. And I would just now, given the evidence, I'll leave it. I'll leave it. And then we probably will have what I hope will be a brief discussion on Monday about it, and make sure you'll have.
When there's no jury present, the judges are even less performative. They take a lot of time. I have a feeling we're going to have some lag time today.
Well, you can get through some super chats a little easier.
Fair.
Yeah, I've got to figure out how to do all these that have come in over the past couple days. I think I'm going to be doing a marathon weekend stream at some point.
The funny part is you'll get more as you do that, and then it'll just be like just living a live stream of super chats, which is not a bad problem to have.
It's like this is
I guess I will
self-reinforcing.
talk about it for a minute.
Oh,
The
okay.
difference between first and second degree, and you're asking that I submit second degree, and it's in the instruction itself on the bottom of. Well, I don't want to say bottom because I don't have them displayed as they would on the page, but on instruction, the instruction you've requested, which is 1022. Under the heading difference between first and second degree reckless homicide, it says the difference between first and second degree reckless homicide is that the first degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. Then, of course, the standard for submitting the lesser is that there's ground in the evidence to acquit on the greater and still convict on the lesser. Where's the absence of evidence of utter disregard for human life?
There's a line of questioning on the cross-examination of the defendant in which Attorney Binger asked, I believe in regards to each person shot or shot at, except for that of Mr. McGinnis, I suppose, if the defendant, I can't remember the exact wording, but if he even cared if he killed the person alluded to. So I believe that the defendant denied that he said he had to shoot him. He denied that he did not care about their life. So I believe the jury could find, based on that line of questioning, as well as just the evidence in general, that the defendant did not have an utter disregard for human life, as he testified. He testified that he essentially had regard for human life because he felt he had to do it, and he didn't really want to kill anyone.
Well, let's hear from the defense.
Judge, element 3 is the circumstances of the conduct showed the utter disregard for human life. And in terms of the evidence in the case, I think the testimony was he didn't want to have to do it, but he did it to defend himself. So, as I said in our instructions, I don't think that there has been any evidence offered which would support the lesser included on count 1. So I would ask the court give 1020, which is the first degree reckless homicide charge, along with the self-defense instruction, and that'd be that, because I think that's what the evidence shows.
I'm going to do a colloquy with your client when we get done with all this. And don't let me forget, please.
I've discussed it with him.
Yeah, but I got to talk to him personally. The instructions says, in determining whether the circumstances of the conduct, and that's a correct point, the conduct showed utter disregard for human life. Consider these factors: what the defendant was doing. He was firing a gun into, let's see, this is count 1, so we're talking about Mr. Rosenbaum. He was firing a firearm 4 times into a human being with fatal consequences. Why he was engaged in that conduct, how dangerous the conduct was, well, that's self-evident. How obvious was the danger? That's self-evident. Whether the conduct showed any regard for life and all facts and circumstances. I don't see it, and I don't see it. Help me out where I'm going wrong.
Good ruling, Judge.
Judge, he was asked if he, not only did he, how he felt about killing them, but if he knew that his conduct would have killed him and that firing that gun would have killed someone.
This element is on first degree, which is what we're not talking about, is whether he knew or was practically certain. And we're talking about reckless endanger or reckless homicide. So, I mean, to fire a gun 4 times into somebody, you don't think you'd know or have or be practically certain that could have fatal consequences?
I would, but the defendant denied that it would.
No, he did not.
No, that's a mischaracterization.
I didn't hear him deny it. He said he was protecting his own life.
Is the judge going to dismiss this charge?
That'd be great.
He is.
Asked repeatedly, and correct me if I'm wrong. He was asked repeatedly questions along the line that you indicated, and he responded, "I was trying to defend my life."
He was also asked the line of questioning.
If so, Twitter's
you
going to
knew
go
you shot
wild.
4 shots
Yeah.
that you would kill him, and he denied that he would have that knowledge. So I mean, I agree.
No, you
that-
asked if he intended to kill him.
I mean, I obviously think that it's utter disregard because that's what we've charged it as. And that's what we have presented to the jury. But I believe a reasonable jury and a reasonable juror could, based on the defendant's own testimony, not find utter disregard for human life. And that's the
Okay,
standard.
so I would just invite myself into the Nick Rakita stream.
I wish I knew the exact answers that were given.
Get to the
I'm
record.
not sure, and I when I say that,
I'll be the
doesn't mean
fifth
I'm,
commentator. Who's this right here?
embracing Your
Hang on a second.
interpretation of what that would mean, but it.
I don't think
I
you're
would
right on
want
the
to be
facts.
sure exactly what was said. Anyway.
I'll be the 7th commentator on Nick Rakita's stream
So,
today.
Are you able to identify when in the examination? Because he had a very lengthy examination.
And you ask the same questions over and over.
Nice. Come on.
That's
You know
also
what?
one of the reasons why you should have a shorter cross, because it can get lost in the weeds easily.
Well, and if you're ever reading through a transcript for an appeal and it gets repetitive, it can be really hard to find that one question that that you need.
Yeah.
And unless it's crystal clear, my suspicion would be if it turned out that the defendant would be acquitted, well, not acquitted, but if the jury returned a verdict on second-degree reckless
said
endangerment
acquitted.
with this description of what constitutes the crime, if they returned a guilty verdict over the defendant's objection, I would expect to be reversed.
Nice.
Whoa.
Wow.
That's saying he's denying the
Yes.
motion.
Or,
Yeah, he's going to deny it.
homicide. I'm sorry.
So you're saying if the jury finds the lesser
On this charge,
and the defendant objected
over the defendant's objection,
and you accepted it,
right?
you felt it'd be reversed?
Yes. Unless you can come up with this crystal clear language that
You're
the
understanding
defendant-
now, fat boy.
What?
That's what he said.
Oh,
What I miss here? What's happening?
Again, we're back to
already going to get mad.
The dejection on his face.
You can
is
see-
palpable.
circumstances
Yes,
of
You can see him getting
right now.
angry.
conduct showed utter disregard for human life. So I think his thoughts on the subject would be relevant, would be a legitimate factor. But when I consider the others, what he was doing, firing into somebody 4 times, why he was engaged in it, there's dispute about that. But either it was.
So,
It would certainly be reckless under.
okay, so the elements of murder. Well, they're trying it. The charges are against Kyle. The judge is saying is going
How
over.
dangerous it was, how obvious was the danger, and whether the conduct showed any regard for human life. And if anything, it seems to me he would have indicated, if you interpreted his answer, it would be an indifference. Although he did say at one point that he didn't want to kill anybody, but it would be an indifference because when he's asked
Whoops.
about his intent, what was the question you're saying again?
Has he talked himself out of it?
No, no. He's
There was a line of questioning on if he cared about killing someone or cared in that regard. And there's a line of questioning is you knew that firing the gun could cause death, and I believe he denied or indicated he didn't know.
I don't remember that.
He would have said he doesn't know it'll
Everything
kill
that
them,
he said. I mean, the reality is, everything was an
but he knew it was deadly force.
intentional act. Now they haven't charged it that way, and I appreciate that. But looking at the definition of utter disregard under the statute, I'm not going to repeat. I'm going to hold the same ground that you've already done. Firing 4 shots,
Good.
we have evidence that the man grabbed the barrel of the gun. So we're talking about a distance of inches, not always feet, but in some situations, inches. It is the only logical conclusion would be that a person would believe that conduct, if they were convicted, would show an utter disregard for human life. If self-defense isn't accepted, there's no other reasonable conclusion that can be drawn from firing a gun somewhere between 1 and 4 feet, all the way down to inches by the soot on his hand. So I think that's what the evidence showed. And I think that's really the only evidence regarding the utter disregard portion of the statute. So
If the defense is going to stipulate to the third element, then that's fine. We can go with that way. But it seems they're not arguing it. If we want to go that way, then we can.
Conversations with lawyers are always interesting.
Especially when one of
there's
them's a salty
Um,
bitch named Kraus.
Yeah, interesting is a nice way to put it.
Disagreement, or they must be trying to argue it. So I believe that there is a basis. I cannot recall at this moment precisely where in the cross-examination it
Well, you
occurred.
should. If
Obviously,
your
it was lengthy and
your whole application is based on
I
this
was not
statement, you should have highlighted
The
it.
examination, as I recommend, as I recollected, was that the defendant
Fingers
was
on his phone.
repeatedly asked
He is. Oh,
Oh my!
Oh,
about
how is that
Judge,
allowed?
rip
the
into him.
question about his thoughts
Maybe
on the
he's
subject
googling
of
Westlaw
Are we
as we
bothering
speak.
you?
death or survival
Bringer?
of
Are we distracting
the
you, Mr. Binger?
target, and invariably responded that he was trying to defend himself.
To be fair, he's trying to line
that
up a
he'd be
job
killed if he
interview.
didn't. And if anything, I would interpret it as an indifference towards the outcome with respect to the target, which is not identical to
That's not reckless
utter
disregard.
disregard.
Right. So if he's indicating he has an indifference, that would be second-degree reckless homicide.
Now, it would be one factor, and I don't, even if I granted what, I just don't think it's appropriate. And I'll repeat my statement. If I were to give this instruction over the objection of the defense, and the jury found a verdict on it,
It's his way of saying you better
I would
object
expect
because
to
you
be
never do.
reversed.
They already did.
Well, are we in agreement that element 3 is present?
Well, don't ask me. I'm not in a position to agree to anything. I'm not going to give
Nice.
that instruction.
Cute. Nice. Good for you.
Or submit that verdict. 1345
They
and
lost that one.
1347.
Yep.
Okay, this is one indication, though, of
Second-degree
why
reckless endangerment.
putting the defendant on the stand was so dangerous. Because if they get that lesser included charge, it allows the jury to compromise the severity of the initial charge and go, I think he's wrong, but
Yeah,
not
it is.
this
So,
wrong. And
Any
that's what the
additional
prosecution
argument on
wants.
that?
That's why it was so dangerous to have him on the stand.
And just
So
a
to-
subtly different answer here would have been enough.
Right. So to clarify, what the prosecution was doing here was they were trying to introduce a lesser included charge, right? They weren't. So it wasn't that the defense was trying to get rid of the reckless disregard charge.
Right.
Like, I'm confused in this because I think what they're trying to do is lawyers have this problem. They always try to give more credit, or they think other people think like they do, without taking that step back and realizing that no, you know,
Nobody thinks like a lawyer does.
It's a
So I
nonsense
believe in
charge.
firing 4 shots and
Did they get the house in on
somewhat,
evidence?
I would say,
There's
violent
Lambeau
manner.
Field. There's Lambeau
He is
Field,
showing
40
that
40
the
miles
argument
behind it
that
also.
So get up on the
he
stand
says
there,
he
Kraus.
says it I believe again that it's under disregard, but a jury could find, because he did not know Mr. McGinnis was there, that he was not showing utter disregard for Mr. McGinnis's life, and that the second degree endangerment would be more appropriate.
Defense.
Object.
Just give me 1 second here, Judge.
Lacey's thinking.
Because it stems from, and tell me if I'm wrong on this, because it stems from the actions involving Mr. Rosenbaum, which this court believes the proper instruction deals with the utter disregard for human life of Mr. Rosenbaum. Those actions, to me, are intertwined with the charge involving Mr. McGinnis.
No, I don't think so, because I think the instruction
on this one is stupid.
anticipates that he could have utter disregard for.
Turn those wheels, Judge. He's right. It's transferring intent to a target behind the intended target.
Could have utter disregard for the life of Mr.
I mean, the prosecution is really reaching.
But still be sufficiently aware to realize the risk to Mr. McGinnis, and then he, under the law, as I read it, he would have the obligation to exercise his conduct in such a way as to minimize the risk to Mr. McGinnis, whether privileged or not. He would, even let's talk about it.
Is there any evidence he didn't?
Even though it's not charged.
Yeah, it
If
should
he
be a directed
intended to
verdict
kill
on it because there's no evidence that he did.
Mr. Rosenbaum, and whether he was justified in that or not, he's still required to execute his intentions
If
in a
this
way with minimal,
if this charge had been there from the outset,
or to minimize.
it
the
should be
risk to
removed on
Mr.
directed
McGinnis.
verdict.
So if, and that's a
So why would you
jury
allow it in
determination,
now? Because there's no
I'm not
evidence to it.
suggesting I would want to be in that position. Who would? But he would have to decide. Well, I've got to kill this guy, but I've got to do it such a way that I don't hit anybody else.
In
That's
0
really
seconds.
what the
Yeah,
jury
exactly.
Yeah.
That's always been my thing. With what
asked
time?
to determine. And yeah, there are instances
Just fire up your
that
time
you would
machine
imagine
and
where the person actually would have freedom of choice and a conviction could be appropriate. One might not expect that to happen under most self-defense circumstances.
Yeah, not this
but,
one. Because there's no evidence. We had a whole trial. There was no evidence. That he was
although
being
for an
reckless.
intentional, then he'd be guilty because he intended to kill someone else.
Yeah,
My
that's
only
the-
argument is
Yes.
Intent
I think the
follows the bullet.
testimony was
You're right.
the bullet that has endangered McGinnis passed through Rosenbaum, right? That Rosenbaum was shot. There's 5 wounds with 4 shots, so he didn't miss. So the reason that I'm kind of hung up on
He's so close.
the
also,
utter
you could've
disregard for Rosenbaum is if he would have missed, I suppose, and you could say that shot was a wild shot.
But he
and
was
that-
using steel-jacketed ammunition.
But that wasn't.
Bullets are bullets, Judge.
No. I'm picking at hairs because that's what
Was
we
it
lawyers get paid to do.
steel jacketed?
But,
Was that testified to?
It wasn't-
You know,
no, it
and
wasn't.
Of course, if we were in the
That's what I was
jury
gonna
room,
say.
we laugh at each other for the things that are being
Did
said.
not bring that in. They did not
Yeah, so
testify.
dismiss the charge. I mean, come
That's
on.
why
You know,
dismiss it.
in
That's
the
why no
eyes of
reasonable
the
jury could say
jury,
it.
They could theoretically,
No, they couldn't. Not reasonably.
like how
Not
many angels
reasonably.
fit on the head of
It's
a
got to be
pin.
what a reasonable jury
They could
could
theoretically
find.
think. Well, it does make a difference because he wasn't using expanding ammunition. He was.
We don't have
reasonable doubt.
expert testimony on this.
But yeah, no,
Yeah,
I would
They
immediately
also
say, but
had
you know what?
to
The state of New
show that he
Jersey,
didn't
hollow
shoot
point
the
ammunition is
either.
illegal because
That's
the
correct.
Jersey's
Yeah.
decided that hollow point is more deadly
He did.
than
He did
Do we
indeed.
Still
have
jacketed.
any
That was my
expert
point.
testimony to say that the
Uh,
ammunition
or
was
plate,
measured?
copper plate, whatever, jacketed.
If he's
Blah.
using utter disregard, or the jury believes there's utter disregard as it relates to Mr. Rosenbaum, the charge as it relates to Mr. McGinnis directly relates to the bullet that went through Mr. Rosenbaum's hand or head or
that
whatever
makes
it
some
is, right? So that's why I'm saying if it's that for Rosenbaum, it has to be the same for McGinnis only because there's not a wild shot. He didn't miss. He wasn't spraying. Nobody's
It's
alleged
not that he didn't miss.
I'm
It's
going
that
to
he's
say that in your argument,
close to
couldn't you?
miss. So there's no
If
way
I left
he's
this
gonna hit
on
someone
their
else.
verdict and you had to argue it, you could say.
I certainly could.
Pardon me?
I said I could.
The evidence does show that he essentially missed the third or fourth shot. There's a graze wound that then traveled who knows where
Essentially
possibly
missed.
Mr.
That's
McGinnis.
not a miss. That's
So
a
this
hit.
is right as
That's
though
not missed by hitting.
all 4 bullets entered Mr. Rosenbaum. One skipped right by him and basically had contact with. And the defendant says he didn't think he was there.
0.239
So
second
a
shot.
reasonable jury could find that how do you
That
show
was
utter
reckless.
disregard for Mr. McGinnis when the defendant claims he didn't even know he was there?
I'm going to think about this one. My inclination at this moment, to repeat my former statements that have caused some consternation, my bias would be in favor of submitting that verdict and giving this instruction. But if it shows up on your doorstep, your email doorstep tomorrow at some point, and it isn't in there, don't be terribly surprised. All right.
Huh. Okay.
That's confusing.
Whoa.
I don't know what he
That,
said.
that jury instruction is terrible. I mean, just in general, it's terrible.
Here's the thing: whatever happened to
Essentially the same issue, except
when the
obviously
law's
this-
ambiguous, it goes in
there.
favor of the defendant.
Essentially, my arguments that I believe firing 2 shots, missing, a reasonable jury could find that he was not showing utter disregard. He only fired twice instead of 4 times. He did not fire into the individual after already striking him twice, as he did with Mr. Rosenbaum. He did not continue to fire. So I believe the mere fact that he fired twice and did not hit a reasonable jury.
What charge is this
Yeah.
now?
We believe that first
Jump
degree is the
kick
most
man.
appropriate charge, but a reasonable jury could find that because he stopped firing, he was not showing utter disregard.
This is jump kick man. It's a lesser
talking now
included
about
of
the
reckless
jumpsuit.
indifference.
Jump.
Basically, because he missed is the
Yeah.
argument here.
What do you call him?
Blue hoodie man.
What do you mean?
What?
Oh, attempts to.
Did you want to respond?
You know, I try to tell those people.
It's the first time
They
I've
always talk about like
heard
training.
that.
It usually just like target practice.
When you're firing from point blank range, means that you're not showing an utter disregard for human life. So he fires
True.
I mean, Judge, he's on top of him when he kicks him in the face, and you saw the shots. It is difficult to ascertain an argument that a jury would believe because he stopped shooting or missed from point blank range with an AR-15 that he wasn't showing utter disregard for human life. I don't think that's a logical argument. I think the appropriate instruction is 1345. They're either going to accept that it was self-defense in that or they're not. But to say point blank range, 2 shots on a man jumping on you, yeah, that might not show an utter disregard for human life because either he missed or he stopped. I just don't buy that as logical, and I would ask that you just give 1345.
So this is weird because you have to argue against
if his
yourself on the
conduct-
lesser included charge
the
for the
standard
higher charge.
For the lesser
Really,
included,
exactly.
I think is
Yeah, just in
still-
case people think he switched
there is
teams.
ground in the
He
It's
hasn't.
very,
evidence for
it's very
criminal
confusing to the
greater
audience, I'm sure.
Yeah, no, that makes sense.
Yeah, I think there's a lot of confusion in the chat about
We need,
Same
we need to
stuff.
walk them through what's happening.
What's the difference
We need to pause
in what you're charging
on
and the
in the
lesser?
court.
I've seen what I mean. The
Your Honor,
difference is
can you
my
pause?
worry
We
is
can
that
explain.
the defense, who is, I've asked now a couple times if they're just going to agree that there's under disregard, and they've not agreed to do that, is that they're going to get these instructions and then argue it in their closings, and then we are stuck. So I would like some sort of limitation.
Why wouldn't they argue in the closings what the instructions are?
We'll
That
explain
they
when we
will
get a
argue
break
that there's
here.
not under disregard. That they will argue the opposite of what they're saying now.
No,
after
I'm not hearing that.
Then why not agree to it? If they are agreeing that
Because
there's
they're
under-
nuts. That's why. How would that be?
Basically, he's complaining
They'd
that
be nuts.
they're not going to plead guilty.
Why in the world would they concede an element like that?
Exactly.
well, they're conceding it right now.
No, they're not. They're discussing it for purposes of whether or not the lesser
Conceding
included
it
should
right
be
now.
given. They're saying they're not conceding all your evidence. They're saying it's hard to believe that this would constitute or not constitute or
Prosecutor
disregard for
whiny.
human life.
This is when the
repeat
dumbest
question
person in the
I just
room
asked
thinks
you.
everyone else is stupider than him.
This is not. I don't think there's a dispute in the evidence as to this individual, Mr. Jumpkick.
This guy in Grosskreutz need to
Mr.
play
Jump
chess.
Kick guy.
The
With what
video
arm?
is claimed to depict that he kicked the accused in the head. That the accused turned and fired at him twice and missed. On what ground could they convict him of the lesser without having convicted him of the greater?
Well,
There's-
again, I'll stand by the prior arguments of the defendant's own statements, and also I think it does make a difference that he shot 4 times at Mr. Rosenbaum after he was already crumpling to the ground.
Nope.
Dude,
that's
that
a
is
lie.
not how they did not
Shot
get
was as he was falling to the ground.
the
And
defense. I
he
blame them for
stopped
this.
shooting at
They
the
should have
man in
had
the hoodie.
expert testimony
Uh,
that shows that you do not have control of yourself.
To be fair, he was getting hit by a skateboard. when he
Not what
stopped
I'm
shooting.
trying to say, but anyway,
is the
you
appropriate
start pulling the
charge,
trigger and
I
you
think a
continue to pull the
reasonable jury
trigger.
can say, why
They've
did he
already
stop
done
firing?
many studies on this,
Why
and
did
all
he,
around New York. New York cops are like the
fire
most
him? Is
undertrained in the
he went
world.
away?
Prosecutor
And
I
those
feared
dudes,
he
like,
run at
they
him.
just
So
waylay
I believe a
rounds
reasonable
into
jury
him,
could find that,
into a
and
suspect.
Frankly, if
And
the defense,
what happens is,
in their closing argument,
I know, you
tries
can't
to
hear a
quibble
thing.
with the utter
I can't hear a
disregard,
thing.
I've never expressed it before, but I think we're going to
What
have lesser
happens-
includeds after that, because that we're going to answer lesser includeds after that. If
I'm sorry. I'm mad. I'm just
They're
mad.
admitting here that there's no way a reasonable jury.
So what happens is you're attacked. You're in fear of your life. You go into such a defensive mode at that point that you just start pulling the trigger. And if you have extra magazines, especially you train that way and stuff, you'll drop that mag and you'll put another one in. And all this goes back to when New York used to carry revolvers, and enough people started saying like, yeah, Joe shot the guy, and like I look over and he's just standing there clicking. He just keeps pulling the trigger, and the revolver the hammer still falls and everything, and it's he expended 6 shots into him. They pulled the trigger like 10 more times. It's a reaction until that adrenaline, that fight or flight gets out of you. That happens. 4 shots is very controlled. Police train for 2 of the chest, 1 of the headlights. Where's my thing? God, I'm so mad.
Attacking him, and the state says the man had the right to attack him, and the defense said he didn't. Either way, he was doing it for what he was doing. It was purposeful. How dangerous was the conduct? Well, the defense is not disputing it wasn't dangerous behavior. I don't think they're going to argue that. How obvious was the danger?
The defendant denied that it was obviously dangerous. He said he did not know if it was going to kill him. He did not.
That's not the same as
He
danger.
denied knowing that his bullets were more dangerous than other types of bullets. He denied knowing that his gun was more powerful than other guns.
More lethal than other lethal.
I don't know if a bear is going to
Yeah.
kill me, but the
I
bear is
think
still
the evidence
dangerous.
most
I don't think that is exactly.
He got more
He
lethal
just
Thank
keeps
you.
guns.
mischaracterizing Kyle's testimony.
They're trying to say he got more
He's
lethal
got
guns.
nothing
I'm
else.
sorry, I keep fiddling with my.
That wasn't
It
it.
shows you
Actually,
what a great job
kind of
Kyle
intrigued
did
about
it.
to
Was
lie
it
about what he
close
said to
contact?
try and get
True
him
The
that.
in.
suggestion was being made by the questioner, Mr. Binger, that the rifle is because it's a more powerful weapon was more dangerous or something to that effect. And of course, in a close contact situation like that, it may be that the pistol is a much more desirable weapon. But I thought that discussion was focused on that type of issue rather than your claim that the defendant was suggesting his weapon wasn't dangerous? That it wasn't obvious, the danger wasn't obvious?
He's recommending salads.
I think the only gun Krause has ever fired is the Taco Bell sour cream gun.
Nice.
In his testimony, the defendant said, essentially, I was in fear for my life, but I didn't mean to kill him.
Yes.
Is that what he said? Or did he, when he was asked, did he mean to kill him? He said, I was just trying to defend my life, or words to that effect.
He said, I did not want to kill them.
Did he?
Okay.
I don't remember. Mr. Binger says yes. Mr. Krause says
He also acknowledged.
Put the bullets
I
into
think
the
that's
guy.
fair. At some point or another, he did say he didn't
But
want to
he
kill
also
anybody.
acknowledged
That's
that
true.
firing the gun was deadly
But that's
force.
not the element. If for that,
Every single
if for
time.
a first degree, then that'd be another matter. This is reckless. This is reckless endangerment.
Right.
We're talking about the defendant's mind and if he had utter disregard.
No, we're talking about how obvious was the danger.
Agree. The state, under their evidence, is showing utter disregard. What we're fighting about is that it's not.
They do?
I'm still struggling with what is the basis upon which the jury could acquit of the greater and convict of the lesser, because that's the standard.
If they believe the defendant, they have a basis for the lesser included. There is a basis.
The
If they
defendant
if
said
they accept the defendant's
I didn't want to kill anyone.
that I didn't want to kill anyone, that he bought the gun because it was
That
cool.
would be that. I might even buy into that. I might. Except that that would be if we were talking about a charge of count. Four. Because intending to kill is not an element of this crime.
Shows that I had utter disregard if he's
No, it does
firing
not.
not
You know,
considering.
you're getting to the ultimate fact. And I'm telling you what the factors are and determining whether there's utter disregard, and you're telling me that one of the factors to be considered on whether it's utter disregard is utter disregard. That doesn't make any sense.
Well, like I said, I believe the defendant's testimony gives a reasonable jury a basis to find a second degree.
I don't.
Ooh.
Correct.
So I will not give that instruction
So they lost
or submit that verdict.
on. Did they won on one? Lost on two.
The judge is
And
undivided,
reason is
undecided
because
on
I
the
do
I
not
second.
think number 2 he
Or-
didn't decide.
In the
Okay.
evidence for
I thought
acquittal on the greater.
I think they lost two, and there's one
And
that's still
conviction
up
on
for
the lesser.
decision.
All right, I
Yeah.
came back.
Yeah, that's right.
I did come back, right?
None of this serves to acquit. Just to be clear to the audience, none of what they're deciding here is a motion brought by the defense to acquit Kyle. This is a matter that the state is trying to just tack on more and more charges that are smaller than the charges they already
Count
levied.
4. Number 2.
And the judge deciding whether or not to
You're asking
allow
for
the jury to
1017, which is,
consider those charges, or whether he's not going to
You're
burden
asking
them
for
with
3 lessers.
deciding on
First,
those
you're asking
lesser
for first degree
charges.
intentional.
And the jury's not in the
You're
room
asking
here
for
for
second
any of
degree
this,
intentional,
so that's why they get to
or-
discuss so candidly.
first degree reckless or second degree reckless.
Yes.
When we get
So,
a bigger break,
now
we'll
give me the
explain why they're taking the
bases
sides they're saying.
For
and
acquittal
sound like
on
they're
each of
they're
the
in bizarre
greater
opposite
crimes
world.
and conviction of the lesser.
Well, with first degree intentional homicide, obviously there's a self-defense. The jury can find imperfect self-defense and
Okay.
find second degree intentional homicide. That if he did not reasonably believe the force, if it was not if it was not reasonable for the amount of force used, the defendant, again, while testifying, said he did not mean to kill Mr. Huber. So they could find from that alone that there is not an intent at all and go to the first degree reckless. And then we're left with the argument that we've been having all morning thus far, which is whether a second degree reckless showing utter disregard would be appropriate. The defendant said he didn't kill him.
The daily double.
The defendant gave his reasons why he
Which is
thought he
ironic.
had to shoot him. But again, I believe he indicated he denied that he knew it would kill him. And essentially, it's the same argument that's been being made all morning. But I think it's quite clear that in a self-defense case, second degree intentional is appropriate because the jury could very easily find in this case that it was not perfect self-defense. As a person who is running at him, being told or perhaps even witnessing himself that the defendant has already shot someone, gravely injured them, has already shot at another person missing, and then gone in to try and disarm him. The jury could find that it was not perfect self-defense.
Are you disputing that?
No, first and second.
First and second,
No.
intentional are okay.
Yeah.
Okay. So then the reckless, the defendant testified directly that he did not intend to kill him.
Can you dispute as first degree reckless?
No.
Okay. All right, any objection to second degree reckless?
For the exact same reasons that we had talked about, Mr. Huber, I'm sorry, Judge, if you already.
No, that's all right.
Mr. Huber has the evidence was a rifle pointed up against his chest.
I didn't hear you.
He has a rifle, according to the evidence, he has a rifle pointed literally up against his chest. So the idea under those circumstances that having an AR-15 pointed buttressing up against your chest would not be utter disregard for human life if believed, to me, that's where it begins and ends. There is no other explanation. So I think first degree, second degree lesser included, first degree reckless are all appropriate. Second degree reckless doesn't fit.
Did you understand?
Understand my arguments before.
Which you've been losing on
This
all day.
afternoon, we may review the defendant's testimony, and if I find a specific thing that I think changes it, I will obviously contact the parties.
Okay. I embrace the argument of
Strike
Mr.
three.
Shrafsi. And count 5.
So that's rejected. That's number 3 they lost. He just said
Well,
I
they did
raised
get
the argument.
2. They got 2 lesser includeds in there, just not the third lesser included.
Did they?
And that is charged
Number 3.
as
There was one that he didn't
intent to
decide
kill.
on yet.
No.
Correct.
In that particular charge, there were 3 lesser included charges.
Is attempted first and then attempted second
I got it.
for very much
What
the
are the
same reasons as
charges?
Mr. Huber, that a reasonable jury could find imperfect self-defense, as Mr. Grosskreutz was actually facing away from the
Bear
defendant
does
when
have a
he
lapel
fired.
pin.
And then
Oh, he does, yeah.
the next
Weird.
Just
It's
lesser
camouflage.
included, if they don't find intent, is the first degree reckless endangerment. So I've requested that, and then obviously I've requested second degree reckless
We'll
endangerment.
explain this in a second when
which
they're done.
We've rehashed a few times now.
Depends.
Judge, I don't have an objection to the lesser included on the second degree attempt. It's the same argument. The court heard the evidence in the distance. Mr. Grosskreutz testified that he was about 3 feet away, whatever it was from him, when he was shot. The gun, Mr. Grosskreutz pointed the gun at the defendant. Mr. Rittenhouse then fired. So I think that first degree, attempted first degree, well, you can't attempt a reckless act, right?
And
Yeah.
I would have told you, I would have agreed with you some years ago, but I'm not sure. I don't know the answer, and I certainly am going to have to hit the books on that.
Doesn't make logical sense.
That was certainly once
sense.
the law.
I would have, you either are, to me, you're either reckless or you're not reckless. So I would object to any recklessness
Yeah, I understand
because I
what
don't
you're
think
saying.
you can attempt a reckless act. So I'll
If
leave
you
it at that.
intentionally go out and
I think that's
you're,
How can you
Sounds
try
like
to be? How can you try to be not trying?
if the roads are,
But I think somebody would say you're the
No,
behavior.
if you drop an
is
envelope,
either-
let's say you drop
it's
an
either
envelope off
reckless
a
or it's
bridge,
not.
you're being
I
reckless.
don't know how you can attempt to be reckless.
That
Or
itself
attempt to be
is
negligent.
Good
reckless.
logic.
I don't know how
Intentional
you can
act.
do those things.
you intended to
You're
to drop
intentionally
an
dropping
envelope.
an envelope
We,
off a bridge.
we
That was
just
right.
Yeah, but
basically
that's
agreed on
what-
the kind of
Pending
reckless
to hit
homicide is
anybody.
appropriate. Mr.
It's called
Northwright
attempted
did not die,
recklessness.
so the
Just a
appropriate
second.
charge at this point would be the first degree recklessly endangering safety.
I see what they're saying. Though. How can you attempt to be reckless? Attempt reckless, I do see that as being difficult. You can either you are reckless or you aren't, because I mean, when you attempt something, you have to fail at it to attempt reckless. I think, or you are reckless. Yeah, so it's either you are or you aren't.
Would be recklessly endangering his safety. If the jury does not obviously find that it was perfect self-defense.
Is it a lesser included?
Yes.
Statutorily?
Yes.
Yeah, I think you're right. Because otherwise, why couldn't they convict him of both? But why get into a discussion we don't need to resolve? We'll have it. We'll do it later.
This judge loves law. He
I
loves
don't know.
talking
I'm
about
going
it.
to think about this one. I'm inclined to agree with Mr. Kraus. Okay.
On count 6, we are not requesting any recklessly endangering safety charges, so we can skip that argument.
Bless your soul.
What?
Now the defense has submitted, and I don't think you submitted anything standard except standard on that.
Our position is they've never raised the affirmative defense. So that's why we didn't do it.
At the trial.
Correct.
Let's see.
And
It's not an affirmative defense.
obviously, they can argue otherwise, but that's why we did not prepare one. Obviously, they can argue otherwise, but that's why we did not prepare one.
So now we're talking about the minor possession of a firearm charge or of a deadly weapon charge. Again, they're alleging that the exception is an affirmative defense, which it is not, in my opinion.
You know, I want to point out that I don't have the record of this in front of me, but my recollection is that for self-defense, you can use anything for self-defense. So self-defense in and of itself is a defense for using whatever. So they're trying to establish intent of when he left the house. Well, he didn't leave the house. They've already destroyed that. I mean, I don't remember if during trial they asked when he was handed his rifle, right? What I would say, I'm surprised they aren't trying to game on a straw purchase for the gun. I shouldn't be helping the prosecution, but here's the thing: if you're defending yourself and you've got the only thing you're stark naked, you just got out of the shower, it's cold and the wind's blowing, and you walk outside and you go, "Here's a crate. Look, the UPS has delivered a crate." You open it up, it's full of hand grenades. And you're like, "Oh, wow." Then you turn it over to your left and you look, and here comes Rosenbaum saying that he wants to rape you, and just like he did in prison, the 5 kids, he's gonna, whatever. Just following his record there, YouTube. Don't get upset. This is just a pure hypothetical make-believe thing. I wanted to say zombies, but zombies don't have a legal recourse. So you look down at these hand grenades and you think to yourself, and by the way, I'm basing this all off of Bugs Bunny cartoon, my hypothetical here. And you pick one up and you throw it at him, and it blows up. Well, you're not supposed to have the hand grenades. Those are dangerous weapons. You have to fill out a bunch of paperwork, pay a lot of taxes, all that other crap. However, you got them. You use it you defend yourself. You're in imminent fear of of death, right? You do not go to jail because you have hand grenades. You kill someone with hand grenades. It's self-defense. You grab something. Just think like you go downstairs to get a glass of milk, okay, in the middle of the night. Also, you hear something crash at the door. You grab whatever's next to you. Maybe you've got a flashlight. Maybe you got a kitchen knife. Whatever it is, you're not thinking. That's not the intent of self-defense. There is. Oh, wait a second. I've got to have a gun that doesn't look too cool. Can't have a sling to carry it around on. They're really reaching here. It shows a lot of the mindset.
Raise the issue.
I understand, and I don't believe that they have. There's no testimony on the authorization, the certificate of accomplishment to obtain authorization for hunting. There's no evidence on whether or not he has a certificate of accomplishment to obtain authorization for hunting, which is the state's position all along, is that he would have to have that.
Well, they're claiming
hunter
it's
safety
not.
class.
And the state is
See you
always saying
later.
that it is not.
I'm going to try pop in also. Eric, no, I'm going to try.
Well,
pop in.
if the court finds they raised it, which I don't believe asking a general question on the belief of a detective, that is not evidence, the belief of someone.
Well, is it a belief or an observation?
The way Attorney Trossi just said it was belief. We'd have to get the exact question, but I don't believe.
The exact question may become important.
So I don't believe that is raising it. And the defense had every opportunity. They brought the gun over here most every day the last few days. They could go to any number of witnesses to measure it and raise this issue, and they did not.
They don't have to measure it. That's the burden of proof of this on the state.
I understand that, but it wasn't raised. Is our
Well, if he asked the officer, and I will have to see what the transcript says, if he asked the detective whether the rifle was compliant, or what are you claiming you said?
I asked him if there was, I know I asked him about it. The question I asked, I think I asked him something along the lines of, did you believe there was any violation for the barrel length of the gun?
That would put it in issue if the question is like that.
Well, also the statute reads, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.
Because this is their screw up. This is the state screw
Or,
up.
Yeah, I read this the other day. They're
is
all
not in
still on
compliance with the two
Marcus
sections mentioned. So it's an or, it's not an and. We don't have to show all three. So they may have raised the issue with.
You have to show one of the three. You have to show one of the three.
You haven't shown any of them.
No. What am I saying?
It's all of them. The or makes.
You have to
all,
show any of the three which
He
the
failed on
defense
all three.
has put in issue.
So
The defendant has not put in issue the certificate of accomplishment.
Correct.
The defendant has put in issue the length of the barrel.
And Judge, we can unpack this for a minute. So the
This is a
exception
critical
says
moment on this charge.
if you're, it's a violation of the law if you're under 18 and possess a short barrel shotgun or rifle. Okay, that's one way you can be convicted. And it says or are in violation of Wisconsin statute. I think it's 29. 29304. 29304 only applies to people 16 years of age or under.
Right.
There's been testimony that he's 17. Okay, so I've
That
conceded
is true.
because he has to be in violation of both 29304.
Here's the thing. Right now, they're thinking this is such a BS
29593. I concede
charge.
he's in violation of 29593. However, 29304, he's 17. It doesn't apply to him. It can't apply to him because of his age. We put in his age and we put in the barrel. That covers the first exception, and then it goes to or, and it covers the second.
See why
exception.
trial takes so much time?
I provided the court, and I'm not rehashing it, that you had denied the motion for reconsideration. This statute doesn't apply to 16 and 17-year-olds, period. The legislative history that I provided to the court, it says it in black and white.
Well, I ruled as I did because the motion to dismiss attacks the complaint. And the complaint was adequately pled under the law. That was
That
not
was finished
endorsement
trial.
of the state's position on the case. And to use a trite expression, the rubber hits the road here at the trial. So now you have to prove everything that the statute requires.
If they're not writing, if they haven't already written that motion to dismiss on all these charges,
you need to prove
and they're not writing
the
it,
defendant was under 18.
If they haven't already written it, they're nuts.
Time of the incident.
Oh, they should have written motion to dismiss
Walked in the door with
He's
that.
under 18, yes.
And
before the trial
the
ever
barrel
happened.
length was less than that allowed by law.
I'd have
within-
filed a
it was
motion
not
to
within
dismiss.
the
I'd
right
say,
to-
Your Honor, these are
We don't have to prove that.
You don't have to prove it.
bull crap.
yeah, look at Sheriff Easy. Yes, they do. Yes, they do.
I mean, there's no real. Our argument is that they did not raise it. I don't think it's really a disputed fact, but we believe they did not properly raise this first part of the exception. The second part of the exception, they've conceded 29.5.
Go ahead. I'm sorry.
They've conceded the 29.593 portion. He did not have a hunting certificate. So then we go to 29.304, and if it is allowed that simply being 17, he is in compliance with that, it swallows the whole statute, and the statute makes no sense. So
Well,
if the
If it
statute
makes no sense, you're out of luck.
well, if the statute is valid,
That's
it's
awesome.
clear as day that
Void
it
for
says
vagueness.
Yes.
a person under 18
Clear
years
as
of age.
day. I would not say that about this law.
Well, I would maybe not say that about the exception, but the actual law.
If the exception
2A is quite clear.
confusing, then the whole statute is confusing.
It's not
Any
confusing.
person under 18
That
years
is a
of age
piece
who
of
possesses
cake.
or goes
Well,
armed
that's
with a
not the whole
dangerous
What a
statute.
moron.
What's the
That's not the
statute
statute.
here?
Yeah. There's a separate
Our
exception
position
on
is
2A that he's
He is
arguing,
not in compliance
ignoring
with
3C.
29.304 and 29.593. I know that this was scoffed at when I mentioned it before, but 16 and 17-year-olds can hunt alone in this state if they have the correct certificate.
Okay.
gonna be
Under
scoffed
16
at again.
cannot, and that is what 29.304 is addressing. The statute is addressing hunting.
Only in
No,
part.
the basic law is that the rubric is not part of the statute.
Mm-hmm.
The title.
Yeah, the title's not part of statute. That's right.
Yep.
It's like the preamble's not part of the Constitution.
You're gonna get.
The title is possession of a dangerous weapon by a person under 18.
That's
It's not part of the statute.
Oh, thank you, Judge.
No, I learned it at an earlier time when we called it the rubric.
Mm.
Tell it to the shell.
The statute says that. That's what it says in 2A.
Let's go,
He learned it.
Judge.
Um,
Dismiss this charge. I'm rolling on it.
the
Come on,
state's
Judge.
position is that he is not in compliance with those two, and that they have not raised the
Look at
short barrel
Sheriff
shotgun issue. But the short barrel shotgun issue, but they don't
He
really
knows
have
he's
to because
winning.
they can try to raise
There's
the
no
other
short barrel
part, but they have
shotgun
not
issue.
done that either.
By his age, it's raised on the second part. It's raised.
Yeah, that's true.
So that's it. And
Boom.
So that's-
I just want to make sure I've been losing this argument. It's not, Judge, there are hunting portions of that statute, and there are just simple possession portions of that statute.
Yes,
Of
excellent.
29.304. I am not focusing, and I'm asking that it doesn't apply, the hunting part. If you read the Legislative Bureau, what it says is, if you're 16 or 17, there is an exception for you to possess a firearm,
It does say that.
semicolon, done. It has nothing to do with hunting. Nothing.
Not a thing.
This is gonna ruin so many people on Twitter
I,
who've been arguing that this
my
is an
inclination
illegal
now,
possession.
Once
It
again, I'll
absolutely
tell you what I'm
does.
inclined to do is to
Dismiss.
inform the jury.
Oh no.
What?
No.
Put
That
it-
is-
Where's
see.
the jury question?
Well, this is still. I think they're on jury instructions, so this isn't in their motion. They're not arguing their motion to dismiss right now.
Yeah, still. It's a perfect time to dismiss it anyway.
Yeah, Judge.
Sua sponte, move to
Yes.
dismiss. Sua sponte. Move to dismiss.
Legislative history only becomes an issue when there's ambiguity. There's no ambiguity in 2A. It is very clear that 18-year-olds are not to possess dangerous weapons.
That face
So
that he made
wasn't
right
Kyle
there.
Exception to the
also
dangerous
the
weapon
statute in a way
definition
that
is in
makes sense.
3C.
And the way that it makes sense is that
The
A
face that he
company
just made there.
by
he's 17
Super memeable.
does not
a person at
automatically
least 18
I'll be
years of age.
disappointed if I don't see that.
Well, you know, I raised it earlier in the case, and it has
Rosenbaum was
created a lot
18
of discussion,
or
and
18.
I'm off the wall.
Kyle was accompanied
So,
by him.
the penal laws are construed strictly.
Mm-hmm.
Vague laws are. Who is that emperor from
Here we
way
go.
back in history?
Claudius.
Who posted the laws?
Roll on your
Childhood.
emperors. I got
Pillars so
Augustus.
high that the people couldn't read them.
Claudius.
He's talking about his
That's been
childhood
used
friends here.
By lawyers and judges for centuries
Uh-huh.
about the requirement that people be given knowledge of what the law provides.
This is
Thank
Prometheus.
And the
said.
basic law, and it's chipped away a lot of times
Lu-
with the appellate court decisions
Rule
that
of
are made on
lenity.
the subject of and try in efforts to preserve the statutes because some of them
Oh,
are
stupid.
quite messy.
Stupid.
Yeah, because politicians aren't
That's not
lawyers.
criticism. That's a reality that judges have to deal with periodically. Most of the statutes are easily enough worked with. But the basic rule is that the ordinary people should be able to understand what their laws are,
That's true.
so they know what conduct is allowed and what isn't.
Clear.
And I've been wrestling with this, and now I know that there's a lot brighter judges in this world than me, but I've been wrestling with this statute for, I'd hate to count the hours that I've put into it. I'm still trying to figure out what it says, what is prohibited. Now, I have the good fortune of having some experience and a legal education. How is the ordinary citizen supposed to
Yes.
acquaint
Void the
herself
charge.
with what this
Yeah,
says?
yeah.
Make them
Do it.
appeal it.
Sui
Make the
sponte.
state appeal it.
The defendant, Mr. Black's stepfather, the defendant's mother all knew he could not legally possess this gun.
No, that's not what they said. They said
That's why
you cannot
it's
buy
not
it.
up here. That's why Mr. Black bought it. This
Those
is
are
very
federal.
clear.
Those are
Those are federal things.
I'm sorry.
Is that the standard by which the judges interpret a penal statute?
You just said it should be clear to normal everyday people, and it was clear to these normal everyday people.
That's not the
No,
statute
it
about
wasn't.
buying a
That
gun.
Under 18 cannot possess a dangerous weapon.
Someone says.
Doesn't say. Show me where it says that though.
And he can't necessarily possess the gun in Illinois. We're talking about Wisconsin, and we're talking about the law, not what Dominic Black's father might think.
Obviously, we're responding to your.
Well, but the point is, you know, if they put a sign out here, don't jaywalk over to the other side of the street. And that's a bad example because we know jaywalking is unlawful. Supposing they put a sign out there that said, "Don't
Keep off the grass, Judge. Just keep off the grass.
don't use your cell phone while crossing the street." Now, if they adopt a law that says that, and people are, not, as I told the jury before, ignorance of the criminal law is not an excuse. So people are charged to know that, unless it's written on the top of a pillar so people can't see. People, if they're given legal notice, that's why they publish them in the newspaper. If people are given a legal notice of what's unlawful, then they can conform their conduct to the requirements of the law. If they don't know what the law is, then they're just herded into obedience of certain standards. Now, I don't know if that's the case with Dominic Black's stepfather or father or whatever it was, or the defendant's father or whatever. Whether they studied the law, they were familiar with what it says, or they were just afraid to break the law because they heard somewhere along the line that it was unlawful. Well, I'm not allowed to do that. I'm not allowed to say, well, they should have guessed right.
What was
Yeah,
Dominic
that's
Black's?
I can tell you, I've put
That's an
many hours
intent
into it,
question.
so have
That's the only
you.
time that matters.
And
Non-strict stuff.
how are ordinary people not supposed to know what they should be afraid might be against the law. How are ordinary people supposed to know what's against the law?
2A is very clear.
So clear that the judge spent hours trying to figure it out.
I'm going to my intention is to instruct on what he submitted without page numbers, I might add. Looks like the third page. It starts statutory definition of crime, and down to where it says or. So it'll be exception, the state must prove, etc. Then number one, the defendant was under 18. Number two, and that the dangerous weapon was either a rifle, etc.
The statute itself says restrictions on hunting and use of firearms by persons under 16 years of age.
So that it can go to the jury.
Oh, so he's saying he might remove it.
And use of firearms.
All right, now, is that it?
Move for directed verdict.
Video evidence contrary to the defendant's testimony shows that he raised his weapon at individuals, and that is what provoked the attack. By Mr. Rosenbaum.
So, Judge, yesterday, obviously you know why we were fighting about what that enlarged photo, and I don't think that's what I think that evidence is open to interpretation, certainly. I would argue to the court that while Mr. Krause can say that's what they believe it shows, I would submit to you that what the testimony is Mr. Rittenhouse is shortly before that yelling friendly, friendly, friendly. I think if you look at that picture that you saw yesterday, it's open to interpretation. We know he's wearing a strap from the harness over his shoulder. The other thing that if you look at the picture closely, he's standing like he would be firing or pointing that gun like he's left-handed.
Posobiec!
His left foot is back, his right foot is forward, and he's open like you're looking at me now. So in every other instance where you observed a gun being fired, he's firing it from the right side.
It's contrary to how his harness is set up.
His gun hangs this way. Now they're saying that photo shows that he was standing and picking the gun up and doing it left-handed. I think that photo is open to interpretation as to what it is. We believe that it shows a side mirror of the Duramax and part of his strap from his firearm or from his sling. That's open to interpretation. I completely understand that. However, you also heard testimony that from this person who, from the state crime lab, who said he couldn't really answer, and I don't know what you thought of his testimony yesterday, but he really couldn't answer a lot of questions on, and that's why color was so important yesterday, on how the pixels work, and he couldn't say what color those pixels add, and I think that's relevant. Now, it is our position, and I think the testimony supports the idea that Mr. Rosenbaum provoked the attack.
That Mr.
Rosenbaum provoked the attack. Mr. Rosenbaum, there's testimony from two people that Mr. Rosenbaum threatened to kill Mr. Rittenhouse if he caught him alone. You heard the testimony that Mr. Rosenbaum yelled, "Gun, gun, gun," and then you know what was said after that. He's chasing him down. He yells, there's been testimony that Mr. Rosenbaum yells, "F you," before this happens. Mr. Rosenbaum has a gun pointed at him in the parking lot and doesn't stop running toward Mr. Rittenhouse. And if you give 815, which is the provocation instruction, I would submit to you the only way that Mr. Rittenhouse then can be acquitted or found not guilty of the charge is, one, he exhausts every other reasonable means of escape. Two, he withdraws from the fight, and fight is the language in the instruction. And three, he provides, sorry.
Well, go ahead, finish, and then I'm going to tell you why I don't agree with what you're saying.
Okay. Well, I'm looking at 815, but
I'll interrupt you now and tell you.
Okay.
You said if I give that instruction, then the only way. No, the jury may not believe the predicate facts upon which the instruction is based. So he could be acquitted as long as the jury does not believe that the defendant's behavior was provocative.
That's the first line of the instruction.
But, say that again?
That's the first line of the instruction. You should also consider whether the defendant provoked the attack. The defense is still able to give forward their version of events. We have multiple videos in addition to this photograph. And also a defense exhibit number 41, which has its circle on there where the defendant is raising the gun at someone in front of that Duramax. That's an exhibit they have gotten into evidence. So there really wasn't much dispute of this until a few days ago. And that's fine. They can dispute this fact. We believe it's very clear on video that the picture itself was just one little portion, but on that drone video, both the full version and the somewhat zoomed in version that has been provided, it's very clear. I saw it on my television at home immediately upon watching it. So that's our argument, is that he provoked it by doing that. Now, as the court has pointed out, this is not forcing the jury that there's it's not forcing their hand. They don't have to find provocation. You should also consider whether the defendant provoked the attack. And that is a consideration, and that is a point of contention in this case. And I believe it's an appropriate instruction for both incidents.
I interrupted you.
No, that's okay. The last thing that I was going to say is it would also require that he give Mr. Rosenbaum adequate notice that he is withdrawing from the fight.
Getting sound?
I think under those circumstances, that's
for some reason now I don't have an avatar.
Impossible to do. But more importantly, I have found a case. It's from Kenosha.
Ooh.
On provocation and what that means in terms of a self-defense. That is state versus, and I'll just spell it. It's BOUGHNEIT.
Bonet.
BOUGHNEIT. It's at 97 West 2nd, 687. And in that case, there was a gentleman in a diner, and people walked into the diner, and he started to harass them. He tried to grab the women, harassing the women, verbally accosting people. And one of the men that the women were with came over and said, "You need to apologize." The defendant said, "Let's go outside." So they go outside. The defendant ends up going to his car, picking up a shotgun and shooting the man in the face.
Oof.
And the argument was, did he provoke this? Now, there was testimony to everything that I just told you. Did he provoke that by starting the fight, sexually harassing the women, using the language he used, and then ask the guy to come outside?
Big twist is going to be no. Oh, okay, right.
So the provocation instruction is clearly appropriate. I don't believe there's sufficient evidence in this record to support the idea that Mr. Rittenhouse provoked this attack. I don't think that that's there. So I understand that it doesn't require that they follow that and say, well, he did provoke it, but I think there has to be evidence to support that. And I don't think that photograph in and of itself, which is obviously open to interpretation, supports the idea that they have to or should consider whether or not that was provocation at that point.
I agree the photograph alone would not give the basis for provocation.
But
the photograph is the last piece of evidence that was submitted on this. Detective Venturini testified to it. We have pointed it out on videos. We pointed it out to the defendant on the video.
The detective who wasn't there.
Gave what I believe to be a lame explanation
My
for it.
avatar's still there.
So, and again, the defense's own exhibit has it circled on there as it happening. So I believe there's plenty of evidence that Mr. Rittenhouse did raise this rifle and pointed at someone off in the distance, actually Mr. Zeminski. And let's not forget also, I've not given my full argument on provocation yet. The FBI video, well, let me go back. The Corey Elijah and the Drew Hernandez, actually Frank Hernandez videos, shows the defendant walking behind Rosenbaum, Mr. Rosenbaum, on the way to this car source area. At some point, Mr. Rosenbaum begins running. We see that on the FBI plane footage. Our argument is that Mr. Rittenhouse then begins running and following Mr. Rosenbaum. That he follows, if not the whole way from the ultimate gas station, then Mr. Rosenbaum starts running. That provokes the defendant, who is actually very slowly and casually walking for quite some time, seemingly, to then go and follow Mr. Rosenbaum there. He then, and the defense's argument is that this is some sort of ambush. And I don't know how you ambush someone that you don't know they're there, but we'll put that aside.
What?
I don't know how you ambush someone you don't know is coming, but we're going to put that aside. So the defendant runs onto the scene and then is seen by testimony and video evidence gently putting the fire extinguisher down. He says he dropped it, but he places it on the ground and he raises the gun. And I disagree about the left-handed thing that Attorney Trofsky just said, and raises it at Mr. Zeminski. That is all in evidence. It's in a defense exhibit.
Can I see that? Is that readily available?
This guy is so full of crap. It's aggravating. I don't understand why they thought Gage Grosskreutz was like credible.
The state's position is that the running after Mr. Rosenbaum probably in itself is enough to provoke the attack, but putting that aside, certainly raising a gun and with no basis for any kind of self-defense. There's no one around him at the time except an individual in a wheelchair who's behind him. He raises his gun. I would guess because he thinks there's vandalism going on, but we don't know that because the defendant denied that he did it. And then Mr. Rosenbaum approaches. He somewhat drops the weapon. He keeps two hands on it, and then he begins. He has a duty to retreat at that point under provocation, and then he runs. I understand why this instruction is problematic for the defense and for their version of events, but that does not change the fact that pointing a gun, which is in the evidence, is provocation.
They have no idea they're losing this case. This guy really believes.
Oh, wait a minute, no.
Guys, this is an assault.
I mean, I'm concerned that they might be able to thread the needle.
You have to realize why they're going out to the legal system.
What are you talking about?
Talking about the compilation video that the defense put into evidence. I believe it's 41.
I have it on my screen right now on my computer, John.
I have it on my screen right now at my computer.
We'll see if you can match it up with what she's looking at.
What photo is it?
Then you said...
Hell, we already saw how bad they show the photos off.
Something about the running...
Photoshop is a
running
farce.
after another was provocation. Well, how is that provocation? We're talking now about the... you're alleging that the defendant was running behind Mr. Rosenbaum, and that was provocative?
He chased him there.
You said didn't know he was there. How's he chasing him?
He's walking, especially in the video that was put in yesterday through Mr. Hernandez.
Yeah.
He's walking within steps Rosenbaum and Zeminski are lighting the garbage can on fire. He sees my client walking down the street with a fire extinguisher, and there's fires down at Car Source. Mr. Rosenbaum knows where he's going. He's already threatened to kill him. He sees them coming. He's got very distinct purple gloves. He goes down and he lies in wait. There's no chasing going on whatsoever.
Where's the chasing? And how? Where is the chasing? And how is that provocation?
The provocation is the raising of the gun.
Oh, so
the chasing is irrelevant now.
That the chasing was provocation,
I believe it
which
adds,
of course it could be
I believe it adds
if it's
to the
in the evidence.
Sorry. I believe it adds to the provocation that he chased him there and then
The
immediately raised the
prosecution
gun.
wins on this.
He wants the instruction.
What they're arguing,
What he
I'm
just
just
said
listening to them.
5 minutes ago.
I turned the picture off.
We're free to argue that.
I'm playing
It's
this
like
in the
we're
back of
free
my
not
mind.
to stipulate to the third element.
Oh, Richard, shut up.
Yeah, don't get petulant.
What am I looking at?
If the prosecution wins this, you can kiss concealed carry permits goodbye.
Judge, yes, keep asking the question,
simple-
what am I looking at?
I don't believe
Because
it's playing
that's
it.
what the jury is supposed to discern this fact from. There's obviously reasonable doubt.
Prosecution's argued this entire time for reasonable doubt. They've said, well, there's reasonable doubt, so you might as well prosecute. This entire thing. Look at that circles there. Look at those circles. I mean, if you look at them, you just kind of relax your eyes. They look like just bubbles. Just little bubbles.
Show me with the pointer what you're talking about.
Show me with the pointer.
Pointing out that the indicates he's pointing a weapon. I'm just pointing out that this defense exhibit indicates he's pointing a weapon. We have much clearer video showing this.
Show it then.
No, you don't.
Where was that? Why didn't you bring it to trial?
First of all, why did the defense bring that to trial with those annotations that say could be Rittenhouse pointing gun? Those are hearsay and should have been scrubbed.
We'll take a
Yeah.
Oh, I didn't even see that. Look down there in the bottom right. Bottom right of that photo.
What's he taking a break for?
Richards is leaving the courtroom, it looks like, to go get something. Or maybe go to the bathroom. I don't know.
Law book?
This, guys, when we were talking about the foundational issues of all of this evidence, this is a big part of it. There is no reason on God's earth that the defense or the prosecution should have been able to introduce a video that has annotations put on by somebody else who's not there to testify to those annotations. That is hearsay. It's opinion. It's prejudicial. This video should not have been in evidence. But apparently
Everything Nick just said.
The defense is the one who introduced it, which makes even less sense.
That's absolutely ridiculous.
We have seen utter incompetence.
The
from both
defense
sides
missed
here
it. They
throughout
completely
this trial.
missed it.
Utter incompetence. Sheriff Feasey seems like he's the only one there who's ever tried a case before. The state, the Binger's cross-examination was textbook, awful cross. We've seen bizarre introductions of evidence. We've seen the defense counsel sit back mutely, failing to object on
I'm
basic,
against their lack of objection.
crazy evidentiary issues. Objections on hearsay, objections on relevance. We saw them put this guy on the stand, their own client on the stand there. They exposed him towards waiving his Fifth Amendment right. And he said, look, we're on the same board. He wants to testify, and we're on the same page. We support that decision. It wasn't over our objection. So they're on the same page. And your responsibility when you put him up on that stand is that you protect him like he is your own child.
True.
And you stand up there, and when he's being badgered, you're sitting back there with your arm back, like, oh, yeah, I got nothing to do. I'm thinking about my next vacation in the Caribbean. And we've seen so much malpractice here. I don't understand why they didn't move for
Now
directive
that
verdict before they put their case in
is
chief.
damning what he just said.
There was no downside there. If it gets denied, okay. Gets
Malpractice.
Denied.
It
Then they know
absolutely.
if any of it gets admitted.
I'd
If
have
the
to
Gage
disagree.
Gross
It's
Court
gotta be
gets
at
up
least
there and
borderline.
says, I held a gun on him. Right there. Boom. Directed verdict on that one charge. On that one charge. So we know we don't have to think about that moment anymore.
I
We don't
think
have to deal with that.
I think the downside, the theoretical downside would be if you do the directive verdict and then move into your case in chief, you lose the ability to raise or to
The
argue on
politics won't
appeal.
allow a
And I
directed
guess
verdict. The only thing
Yeah,
that
okay.
saves everything
We heard that.
is for a
but then
unbiased
They
jury
can
to
raise
come
the
doesn't
same
make
back
motion
sense.
again.
with
They can raise the
complete
same
Yeah.
motion again today.
right.
And then
I mean,
appeal. And then if they lose
innocence
today,
on
then
all
appeal that.
charges.
where I come from, if you don't do a directed verdict at the end of your case in chief, and then if you don't renew it at the end of your own case in chief, you've waived it.
Yeah.
I
don't.
so you-
It's just astonishing.
I
And the
forgot
and the
what we asked
prosecution.
for a directed verdict for.
We've seen over and over again. We're like, wow, the best person
I
who's
had it in
asking
a,
questions here for Kyle is
Gosh, I'm trying
Binger
to remember now.
or Kraus, where he goes up and blows up on and he everything blows up on his face when he brings up De Bruin. I mean, they did a better questioning of De Bruin than was done on direct. They made Grambo look good. I'm talking about the state. The state made
Yeah.
Grambo look good. The state made
Grambo, I
made
love that's what
Photo
they're calling
Chad
the old
De
woman that
Bruin,
testified.
the photographer there, look good, and made the state look evil and corrupt. How they're trying to get him to change this thing. Every good moment from this trial has come from either the state screwing up their cross, or Kyle actually on the stand and just being like, "Look, I'm just trying to save him. I'm just trying to not die." That's essentially what he was saying. But every time one side had to get up there and question the other side, they would literally bungle it. It was just the only person who looked competent at all is Sheriff Feasy. He's shown real competence at times. And even he failed to object so many times. How many times were we sitting here screaming, "Object! It's hearsay"? They're putting up here documented footage, which is like no foundation. There's hearsay screaming, people talking, screaming, "You're a militia, you're going to kill people." It's all hearsay. And when all this hearsay crap comes up there, they just say objection hearsay. What about objection? The fact that it's labeled saying Kyle militiaman, the guy you're going to indict for murder, whatever file name they have, that they have to show that up there. There's been so much tainting of the jury over and over again.
Well, I'm just.
I'm sorry. I'm sorry. I'm ranting. I'm so
I got a rant of my
aggravated.
own, but I'll save it until after they're.
We're done.
Oh, doesn't look like they're talking. One
Go.
thing
No.
that just annoys the heck out of me with these things is how many lawyers run firearm-related files without a real grasp of them. And if you don't know,
Yes,
hire
listen to this
somebody.
guy.
I mean, there's
Yes.
ballistics guys out there. There's all sorts of people, and
Yeah,
The defense, are we back on?
go ahead.
The defense's position is that Rosenbaum was yelling gun, gun, gun. Why do you think he was yelling gun, gun, gun? Because Mr. Rittenhouse had a gun. Now, I mean,
Oh, go ahead. I'm not trying to interrupt you.
yeah, the court is exactly right. We would have to prove this. We have testimony, video, and photographic evidence of this occurring. It is our
The
burden.
testimony is someone looking at the
prove it.
video.
I agree. But the jury should be given the instruction that they should consider it. Because if he raised this gun, it's clear provocation. So it's up to us to present the proof, which obviously will be a central piece of our closing argument, with the, I think, 3 different videos.
They're introducing
This
proof
defense
in
exhibit,
closing?
which at least indicates that it's there, and the testimony of Detective Antaramian, who indicated he saw this, I believe, after cross-examination or on cross-examination. And the jury can decide it. We don't have to prove it beyond a reasonable doubt to the court or to the defense right now. We have to prove it beyond a reasonable doubt to the jury on Monday.
That's
There is
crap.
plenty of evidence in the record to indicate that, to give this instruction. I understand it's problematic for the defense. I understand it's problematic for their entire theory of the case that they presented in their opening. But that doesn't mean that we shouldn't get it, because we have presented evidence of this provocation, that the unlawful conduct provoked Mr. Rosenbaum to attack him. If the jury buys our argument beyond
then they're
reasonable doubt,
nuts.
fine. If they don't, that's their prerogative. They're the fact finders, not the people in this room. We have presented facts for them to consider. They should be given the opportunity to consider those facts in this light.
In this light.
Judge, I don't think that photograph, maybe I'm wrong, shows anything.
Thank you.
Well, that's for the jury, though.
I understand, but they're asking out of that photograph to give a provocation instruction.
No. We're saying
There's no other evidence.
That's
We're saying
exactly
that
what they're
No,
saying.
no, just a minute.
There's no other evidence. We've talked about the chase thing, right? But every other thing that's come up about what Detective Antaramian said, what anybody else has said, comes from that photograph.
Thank you.
That's it.
No, it comes from the drone video.
Where?
And
Where the
I-
freaking drone
the defense attorney, the defense knows this, which is why they've fought so hard to keep this out. This is not some
The
new
defense
revelation. It's in the
introduced the
police
drone
reports, their
footage.
allegations that he pointed this gun. This is only to demonstrate that a defense exhibit indicates it. We're not using this to prove it. We're using it to show that even the defense exhibit indicates that this is there. We have testimony, we have video evidence, we have, I believe, photographic evidence that helps, but to say that we're basing it on a blurry photograph is completely dishonest.
Accurate.
They've seen this video and they know what's on it, and they know it is problematic for their defense.
I can't rely on what you think they think.
I understand. I'll change my argument. But the simple argument is there's plenty of evidence that the state has provided that he raised his gun. It was a known part of the discovery in this case. We should be able to argue that, and we would argue provocation, so the jury should consider it. And they clearly, as they've pointed out in their evidence and their opening and their argument today, they can rebut that and indicate we have not proven it. And that's up to the jury. That is not up to us. So I believe we should give the instruction is appropriate. It's add the following when supported by the evidence, and it is supported by the evidence.
There's been no secret about my lack of technical awareness in the trial here, and I thought of it. I decided not to intervene yesterday. I did ask Mr. Armstrong some questions to try to better understand what was coming off, but I didn't go further into it in spite of a temptation to do so. When I get messages from some of my friends, my few remaining friends, I have they come as texts, and then they start.
So I don't know why this thing keeps kicking off
in one way or another, and it can be quite lengthy. The exchange that's going on between them and us, but they're entertaining, and so
What is this about?
It's been a couple
About how he
times now.
bungled admitting that picture.
I think.
I haven't figured that out, and I haven't.
Oh,
I have a lot of things that I'm doing, so that's a low priority for me to figure out how to save a text message, and I don't want to leave them on my phone forever. I want it off so that it's clean. So when I look at it, I'm looking just at the fresh stuff. So then I do a screenshot of it, and I email it to myself
I love this guy.
to save it. But I found, to my distress, some of them are pretty long, and they show up in my email.
Okay,
like
I see where
this,
he's going.
Like a little ribbon down the center of the page.
when
Some
I
are even
zoom it in,
smaller
I
than
can't
this.
see shit.
Well, and it's just a blur.
No
Yeah.
way.
Oh my
Oh,
god!
We were talking the other day.
Oh my gosh.
It's a
about
magnifying glass.
Just like a cell phone where you can expand a picture and make it bigger. Well, it's not making it any bigger. It's making it bigger, but it's nothing but a blur. That was my concern that I wanted to ask Mr. Armstrong about, and I guess I should have, for him to explain it better for me as to how that can be reliable. Because it isn't reliable for me in getting my messages on my phone. Now, maybe if I reset it to a site, I could explode it again or decrease its size again, and I don't know. But here you've got a picture, which I have to tell you, I think it's very blurry.
I agree. And the picture is one of 5 or 6 pieces of evidence.
What are the other
So
4?
I know the defense wants to focus on this picture, but the picture is only one. We have 3 videos, one unedited, completely untouched drone video, which I think is where you see it clearest.
What?
And then we have one that is zoomed in, and we have one that is slowed down. I believe the clearest shot is actually the original drone video.
Where?
So we can present that evidence, and they can rebut it. I think you're taking the picture wrong on your phone. I'm not tech support.
Pardon me?
I think you're taking the picture wrong on your phone.
Is that it?
I think so.
I'm not surprised.
But these things are in evidence.
And they shouldn't
He
be.
actually is.
On
For the
yesterday,
analogy,
whether
he's
you
taking the
form your
picture
opinion or
exactly
not.
right.
And that was
Well, my
probably
opinion is not what counts, except to the extent that if there's no,
Oh no!
I'm proud to be
Uh-oh,
American.
God
there's
bless
no,
America.
There we go. There's a new meme.
Trump
What's
judge.
USA?
if it totally, if it's just totally unclear, then I certainly can't give a provocation instruction based upon a picture that I can't
This is
make
really
anything out of.
important.
I agree with you. The ultimate determination
critical.
of
This
what
is
it shows
awesome.
is for the jury.
This is everything.
This
It is
is
not
their
just-
only
It has
hope
to
to
be over
thread
the
that needle.
threshold.
It's absolutely not based on the picture. It is based on the drone video and the testimony. And this was testimony elicited, if not
The
by
state
the
loses
defense,
a provocation
then in
instruction.
response to
Kyle
their
has to
questioning,
walk on self-defense.
Detective Antaramian testified
They
that
should
he
just go
reviewed it
home.
and saw it, and that was a common question in many people in this case. The photo is like the 5th or 6th most important piece of evidence.
What
the
are the
most
other
important
4?
piece of evidence on this point is the drone video itself, and that is unedited.
Show it.
There are some
Show
edited
us.
copies
Show us
as well
right
that
now.
are helpful.
What the hell are you
But
talking about?
to focus on this photograph, that was almost an afterthought simply because we didn't get it till the day before, and we figured it may be helpful at some point. The photograph is, we may not even show that to the jury. It is based on the drone video and the testimony of Detective Antaramian. It is in the record. We have evidence of provocation. I can't fathom why, if there's evidence in there of provocation, which we have clearly done, why we cannot argue
Clearly,
it,
it's
why we
blurry.
cannot get that instruction. The defense is free to completely call it whatever they want and to attack it. But that
Did
is
you
why we
say
have
it clearly?
trials.
I haven't seen it clearly. Okay.
I have.
Oh,
You have.
Oh,
Why don't you just sit in the jury box?
There
and
are
listen?
Golly.
for something
Rain
saying
in
trusted
crowds,
on
man.
notice from the beginning.
Him snapping at
And
the
if they
judge is
wanted
so
to put
stupid.
on the evidence to prove up provocation, all they had to do was call Mr. Zeminski or Mrs.
Thank you.
Zeminski
Oh.
Yes, there we go.
rebut the
Yes.
story that we have.
Maybe they'll
They
come up
didn't
and
put
close
him
it
on because Detective Antaramian, Detective Howard both know that he's a liar. And they're building their whole prosecution on that without putting him on.
well, they don't have to call a particular witness.
But they don't have the provocation. And, we had all these little things going on yesterday, and I went back to my office, and the whole essence of the problem came down to these 2 facts in the testimony. Examiner Armstrong took 20 hours to manipulate that photograph to get that blurry mess up on the screen. We had our expert do it right in front of the jury in seconds, and it showed what it was. And that's where the hocus pocus and adding the pixels and all the other garbage comes in, and that's what they're building their prosecution on.
Again, we're focusing on a picture that is we're focusing on a picture that I have said repeatedly now is the least.
Get rid of it.
Uh,
Get rid of it.
The
Get
least.
rid of it.
Well, show me the next
Convincing.
one.
Well, then if it's
Show me the
Ah,
best
there
one.
you go.
Show me the next one. This man is talking himself into a trap.
Yesterday, before Mr. Armstrong was allowed to testify in rebuttal, we went over this about
Bigger's trying to
whether or
help
not
now.
the methods he was using were appropriate, and we showed you. You walked up to the 4KT, and we showed you exactly what it is we're talking
And
about.
I'm not even going to tell you what I thought when I saw it.
This is not a court trial. You're going to have to find your fact. We have facts.
I know it, and that's why I let it go to the jury.
That's what we're asking.
That's what we're asking, is that the jury be allowed to consider the state's evidence, is essentially what we're asking.
I don't think, Your Honor, you would have allowed Mr. Armstrong to testify yesterday. I don't think you would have allowed him to testify in rebuttal unless you had made some determination that there was some basis for this.
Tell
What
them
I made
he
a
was thinking.
determination was that I thought the jury should make the decision.
And that's all we're asking.
So that's your best picture, the one I saw over there?
No. Just
Where's the best picture? Please.
Please.
Ooh.
Please.
We'll show it to the finder of fact.
You're asking me to give an instruction. I want to see the best picture.
Oh, he's getting upset.
It's the
Awesome.
Because he
We'll
caught
show
them
it
in
to the
bullshit.
I
finder.
mean, he
of
sit there and
fact.
say, "Oh, I'm seeing it," and then you ask
You
him,
need
to
it on
go,
the big
"Well,
TV?
you're not the finder of fact."
Get the big TV.
Get the big
Just
TV.
or reject the instruction. He doesn't want to show you. Why doesn't he want to show you? Reject the instruction.
Get the big TV.
Yeah, you have to show your hand here.
They're trying to gaslight the judge.
Oh, and
Yeah.
he sees it.
I don't know what gaslighting means. I hate that term.
That's why he's
Going
taking
in
a
that
pause
place.
right now. He's calming himself down.
Because every
Yeah,
time I
somebody
think
lit
of
a match and
gaslight,
the whole building
I think
blew
of
up, all the gas
buddy of
went
mine in
out,
high
everybody
school.
was-
Yeah.
He used to light his farts on fire. So that's the image you put in my head when you say gaslight.
I'll go get a TV, Sheriff EC saying, "Look, I got one. There's a Best Buy down the road. I'll be back in 10 minutes."
Believe it or not, I've actually done something similar with AV cords.
Real quick, Russian name says, "Well, I've taught lectures on computer graphics at university for 4 years, and after thinking about these pictures, I'm even more mad. You can have illusory colors via dithering, and even one pixel can change how human brain perceives shapes. That's CSI Looney Bin."
Are you talking
All
about
right,
82?
bring it up if you would.
what is that?
82 is the slow.
No, I think the best picture is on the original drone or the normal speed one.
73, you say so.
If you say so. Judge,
Oh, it's-
turn your ringer off.
Judge,
Turn
I
your
think
ringer.
using the defense, we've
Or-
got the exhibits on our one of our laptops that I think Mr. Stu has. I've texted him to come on over, but I think Ms. Wisco is graciously going to be able to play them for you. I would recommend watching them on the 4K TV. I think that's the best.
4K because you need the
way to see
visualization.
them. So we can set that up. There is the full drone footage. There is the
4K is
slowed
not
down
automatically
drone
the
footage.
best.
And then, of course, we have the photographs that Mr. Armstrong had yesterday. So,
Native resolution would be the best.
Humpty Dumpty really lost control there.
I mean, unless it's their goal to piss off the judge, thinking that when he gets pissed off, he calms himself down and may then allow something he wouldn't normally do it. Maybe that's their plan. It's risky. I wouldn't do it.
Yeah, but here's the thing, he's appeared, according to
I think they
Westlaw,
just-
Binger's appeared in front of this judge 400 times. He knows how to push buttons and how far he can push and how far he can't. He knew
So
he would never
they're
get
gonna-
sanctioned.
They're going to tell the
Again,
judge
I would
that right
recommend,
here
like
he sees
yesterday,
the gun
watch
being
it on
raised.
4K TV,
This will be hilarious.
which if it's not 4K quality.
What's that?
Is it this TV
It's your TV.
adds pixels to something unless it's 4K quality?
Awesome. You're right.
It's your
It's
TV.
common sense and judgment, Jim.
Oh, shit.
Oh!
I'm saying I'm-
Oh, no way!
I'm saying there's no evidence.
Calling me a
I'm
liar?
asking.
I'm saying there's no evidence.
Well,
Oh, look, the judge is laughing now.
You brought in this TV. You
yeah,
brought in the
4K
TV.
drone.
You brought in the TV.
They're getting heated because this is critical.
And they know
Takes
their
me turn
expert
on
just
this.
blew this up yesterday.
Yeah.
I mean, if Richards is 100% right, if you take 844p footage that they have here and enlarge it to 4K, you're doing the exact same thing as pinch to zoom, yet they know even less about the algorithm that's being used because it's whatever proprietary algorithm is being used in the upscaling software that's picked by whatever TV manufacturer they are. And if it's a cord, it's probably like a shit brand from Walmart.
This is the unedited.
Okay.
Is this unedited?
Yeah, this is the unedited.
All right, judge is right there.
So Judge, we're going to be focusing your attention right here at the base of this
Right.
sign. Okay, that's where the defendant is going to come into.
Go ahead.
I don't think he's going to see anything.
He's not going to see anything. Look,
I
judge,
hope-
don't
Can't
you see?
anything.
Don't you see the gun?
It's crystal clear.
You can stop.
Where's it supposed to be?
How did he perceive a gun being waved?
Same quality as our version.
How did Rosenbaum perceive a gun?
Our
being
version
waved
is
in
much.
that
Our
second?
version is much clearer.
Oh, your version is
Well,
much
yeah.
clearer. This
Yeah.
is the evidence that's admitted.
Mr. Stutz.
So what you're showing me now is, this doesn't show anything.
Doesn't show anything.
Yes.
But this is only one of 4 or 5. They have 3 more.
No, they said this is their best one. They said this is the best one.
But there's other ones also. They have,
Am I
like,
peeing
cave
on this
drawings.
thing?
The judge just said,
I don't know how to
and that's
turn
the
that
key. So this is it because that didn't show anything, and of course it doesn't show anything. It never
Look at
did.
Kyle's expression. Boy,
Yeah.
he knows the stakes are. We're all in on. He's all in on this one.
The reason provocation is so big is because
Kyle, stop looking at the law and crime camera.
When you
Oh,
sit
it's
next,
playing weird now. Are you fucking kidding me? It's playing weird.
your
Judge, we
case is
saw it yesterday.
garbage.
Totally,
No.
it's a different file.
Straightening the tie.
the reason. So just explain to the audience the reason provocation is such a big thing. This provocation charge is such a big thing is because as Rungle the Bailey was saying, this is how they could thread the needle. Once they can, if they can establish and allow the jury to make a finding that Kyle provoked them, and that mitigates against his right to have self-defense or changes the yardstick as to what he has to do for his self-defense, all of a sudden everything now changes as what we watched for the last week and a half. And all of a sudden now this flimsy, ridiculous evidence is trying to be used by the DA as a basis to say, oh, he provoked them, and that's the reason why lunatic Rosenbaum went up and charged him. He was trying to protect Zeminski or whatever. And there's
What is that
there's
thing
ridiculous,
outside my house that is so
the
loud?
clumsy, pixel-added, impossible to see anything is their best
Hang on a
evidence
second, I'm
that
gonna
he provoked them,
try to
and
close up some
because of
things.
that provocation
Golly.
is now should be held to a different yardstick and basically be stripped of his right for self-defense.
Look,
And-
it's bugged 4K mechanics, dude. It's bugged 4K mechanics. It's not playing right.
What it really does in terms of the provocation instruction is if you've got somebody who's kind of wanting to convict, but they can't see it, it gets them a way to get past the whole obvious
time.
self-defense thing. And to say, oh, well, it doesn't
My
matter if it's
wife
obviously
raped.
self-defense
Actually
because,
raped.
you know,
Like,
the gun.
Work.
So
Right.
it's not going to help,
We're gonna
help
tell
the
her to make sure
prosecution
that
of
we
the
have a
juror
blower.
who's looking at
But
this
anyway,
sort of fully.
pull these leaves out.
But for somebody who's looking at it with an
Oh,
eye
it's
to
sitting there
conviction,
killing our
I
grass.
think,
Golly, that's
no,
loud,
you're
though. I'm
you're
sorry
100%
about
right.
that.
This is a critical
I'm gonna
moment
mute
on the
myself.
self-defense claims because if they get that provocation in there, it's just like Joe was saying. They have the opportunity in the mind of a juror to mitigate and say, you know, he provoked this, he deserved it, and just having that instruction, they get to read into he shouldn't have been there, he shouldn't have brought a gun, he shouldn't have walked into the hostile crowd, none of which is actually legally relevant, but in the mind of the juror, it is. And that's why this instruction is so dangerous.
And it goes further. If there's a break here.
Uh,
It goes
Billy-
much further also because the jury, once they hear that provocation is a basis that we can change our yardstick for measuring Kyle, they won't just look at this moment. In their mind's eye, they're going to say he provoked them by showing up there with the gun. And
That's
that
exactly
now
what
the
I was
judge has
saying
told
earlier
us that
today.
he provoked them, that they can find him guilty because he provoked them. That's if they see that provocation charge, they're not going to be looking at this stupid video. They're not going to care about that. They're going to be thinking about the fact that by he walking around there with a gun, he provoked them, and everything that happened is his own fault.
Yep.
That's the danger of this provocation
exactly
charge.
what it is.
MSMPCA or CPA, thank you for the sticker of the pair riding a rocket. That was weird. MNSISU says the first to third most important evidence is drone video where Kyle is 10 pixels tall. The fourth is the idiot detective saying he sees that 10 pixels pointed gun. And the fifth is a zoomed in picture of a blurry smudge. What an excellent argument. Do you even know on the picture where Kyle Rittenhouse is right now? Kraus?
His 4K TV.
No, this is the regular. They brought
So
their
looking
regular.
right here, this is the defendant. He puts it down, he raises it up right there. He has it pointed until Rosenbaum approaches, then he runs around.
Try it again.
please.
And can you slow it down?
Nope.
We have a slow. That's what you watched yesterday.
This is why you never want to allow slowed down video, is because
here's
it
the
can
gun.
create all these. You know, it should be seen
there's
as
the
it would have
gun
been
right here.
seen.
As
See
no
the
one
guy in the
there
white
saw
shirt?
it. As no human there saw it.
Yeah.
I can't see
Looks
where
very
he
similar
is.
to that when he points it here, Mr. Rosenbaum.
Well, we know he points it there after he's already being chased by a lunatic.
Here, Stu, let me pause it 1 second and please.
Let me
Let me
please
just
convince
keep
you.
suggesting this. Yeah.
Pause. Right here. If you watch it, when he goes right up here, he puts the fire extinguisher down gently. It topples over, and then he immediately raises
So
up
gently that it topples over.
like this. And the gun is right, we argue, right here. And he stays in this position like this until you see Mr. Rosenbaum come around. So Mr. Rosenbaum, if he is yelling gun, 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 we would argue it's to warn all these people that he is pointing a gun at them, and that he is chasing him out of the area to avoid danger. But if you see right here, the state believes, with all the motions taken, that's the gun. And here's the.
You need a continent-sized TV to see this.
We're screaming gun, gun, gun. Wouldn't that be not to provoke them, but to
You
tell
know, we
them
can
to go away?
talk about this on closings. You want?
I was just curious.
What's that?
I was just curious.
All right.
So why don't you play it from the beginning one more time? You see him drop it right there as Mr. Rosenbaum approaches. Or lower it, I should say. Would you like the zoomed in or slowed down one?
I'd like to see the enhanced one now.
In normal speed or slow speed? Do the zoom in normal speed. Zoom in normal speed.
Billy Witch Doctor says, didn't Greer need to get his own HDMI cable when he sued Taylor Swift? Yes, he did. And he went and got a 3-inch HDMI cable from Radio Shack, and it didn't work. The Dragon's Treasure says, I broke my goal of 1,000 in one day, and it's not even noon. Thank you, everyone. Coupon code 4 doors more whores at the Dragon's Treasure for all your anime-themed tea
So
needs.
this is
Gotta
slightly
go.
cropped
Keep it up.
in normal speed.
Is this when you say, Judge? No, no.
Oh.
All right, now we're at the enhanced video. What they should do is say, Judge, do you realize that that blurry blob that we're seeing the picture of is from
like
this
your
video?
phone.
That's the same thing that we're supposed to be looking at. And so if it doesn't make sense when it's stopped on the one moment where they say it's happening,
So
how are we going to say it's
this
happening?
is the defendant right here. You can see the AR-15 is on his chest. The fire extinguisher you can't see right now. It's blocked by this man in the wheelchair.
For that
But you'll see him
millisecond
walk
that he
up
waved the
again.
gun.
He will
So insane.
gently place the fire extinguisher on the ground, although it will fall over, and then he will immediately raise his gun up and point it at the individuals who are over here, who I think are right now blocked by this street light. But they're the Zeninskis. Okay, go, Brian. See him lifted right there. He's holding it right there until Mr. Rosenbaum approaches. You see the very distinct motion of him raising his arms. You see the black gun being raised. One more time, please.
I love that I'm talking and I have it on mute. I want to know what the model of drone this is.
Open to the camera. So he
No, no, I did
All
not
right,
say that.
I thought the vacuuming was gone. It just went down the streets. Coming back. I'm going back to mute.
Somebody's pointing out that this TV apparently
So
does
here's
use
the
AI
gun.
upscaling.
Puts it down and raises
Of course
it
it
right
does.
here. He still has it up right there, and then he drops it and runs.
I don't know if you can even buy a TV without AI upscaling right now.
Would you like the slowed
Yeah.
down version?
I mean, you
Might be
could, but
shitty upscaling. Might be good upscaling.
Slowed down version, please.
I would just remind the judge that's what I would say. Judge, that blurry blob picture you saw is from this video. That's what they're asking you to see in real time. They want to convince you that that's what you're seeing, even though you clearly don't see anything happening.
None of us see
So
anything.
here's the defendant here.
And the
There's
DA knows it. I want to hear him
right
say
there.
it, and the DA knows it.
Play it,
I'm lying
please.
to purpose. The DA knows
So
better.
he's coming into frame. He drops the fire extinguisher and he raises it right up. He has it up right there. You see him bring it down, and you see him start to run. He's pointing it at Joshua Zeminski, who probably is vandalized.
Wait a minute.
He fires it. What, I'm sorry?
I said, where's Zeminski's gun? I meant, what I meant to say was, does it depict Mr. Zeminski, Mr. Zeminski's gun?
At this point, no, it does show him shoot in the air.
Oh, that's over later, it's over there.
Yeah.
I'm talking about at this point.
I don't believe it shows Mr. Zeminski's gun.
Does it show Mr. Zeminski?
Can you play it again, Brian? He's kind of
Or
hidden.
Mr. Zeminski?
They're kind of hidden by this light post.
You can't even point him out. That's how bad the video is.
This is something people never understand with video, is just how often video evidence is crap.
What I inquired is, well, wait.
What I don't understand is we have 19 different angles. This is the only angle that you could possibly see him waving his gun.
That's what they claim. Well, that and the FBI drone footage from a mile and a half in the air.
Why couldn't they see? Why wouldn't people see it from the other direction?
Because it's made up.
That's what I'm saying. That's what he should be saying.
That he is reported to have fired
The only time anyone sees this is when it's artificially enhanced with pixels being made up. That's the only time anyone sees it.
And they don't even see
We
it
only
then.
know they're there because of the FBI video.
Yeah.
You can kind of see they're blurry. We did not try to do any enhancements.
So you can't
on
tell
that.
where he's pointing a gun if he even
We
raises
know from
it.
the FBI video. We know from the FBI video, Your Honor, that they're in this proximity alongside Duramax. But
Then show us the FBI video.
Closed, and the Duramax is a
I don't
dark
think the judge is
vehicle,
gonna buy this.
And of course, other issues with the video. It's not, and there's poles.
But he won't strike the evidence, though.
They're in that
Issues with the
vicinity.
video.
FBI video, which we can show you, does give you.
I've seen it.
It might be helpful after seeing this now to see that, because it kind of gives you a very good look. So.
If you play it, I think I can play it, please, Brian.
I can pretend to know where they are after saying we don't know where they are.
I believe.
I
They're
think,
blocked by the light post.
They're
But they are
blocked.
right here.
I think this is
I
one of
swear
them
they're
here.
there.
Moving. It's very hard to tell in this video.
Amazingly,
then
Zeminski's do
they
not
walk down
react
this
to
way.
having
This
a
is where
gun
he-
pulled on them, by the way.
We don't accept the defendant's story that he had his gun out because in the video you clearly see Mr. Zeminski pull it out of his pocket, fire in the air, and then put it right back in his pocket. So unless he had the gun out and then put it in his pocket in these few feet, we're not accepting the defendant's story. That in fact, we believe this contradicts his story that Mr. Zeminski had his gun already out because you see on the next enhanced video, you see him pull it out of his pocket and fire it in the air quick and then put it down.
He keeps it down on his side. He's walking right down the sidewalk yelling, "Man, you just shot somebody." You can see the gun clearly in his hand.
Well, this sounds like a great argument. But did you want to make any?
Object to all of this.
Before I make a decision.
Well, you're gonna see. I'm cheating here, right here. You're gonna see what you believe that you see. Okay. So that question is, does that video provide enough information to give an instruction on provocation?
And how does, if we take everything they've said, that's true, how does pointing a gun at Zeminski?
No.
Don't steal victory from the jaws. I mean, defeat from the jaws of
They
victory.
say they don't know each other.
There's no evidence of that. He called Mr. Rosenbaum's dead.
He's screaming gun, gun, gun. Also, because Zeminski just fired. He's screaming there's a gun somewhere.
Any real basis?
Well, the evidence, okay? The evidence in the record of two people is that Mr. Rosenbaum had twice before threatened to kill the accused. So is it, what is the legal effect of a person who, if he made such a threat, what legal justification?
He would have to retreat and clearly communicate. Oh shit. He would have to communicate to Kyle, I'm not going to kill you.
In such a way as to not put the defendant into a position of being a provocateur.
Great.
We are absolutely not. We are not accepting the evidence that threat was made because there are different accounts of where and when it was made, and it's like the only 5 seconds not caught on video all night.
Judge walking down there.
So,
gosh, man, I'm losing it.
But like you said, Judge, it'll be a great argument, and I do not believe that Mr. Rosenbaum does not give up the ability to be provoked because he may have said things an hour earlier.
What?
If this individual, now remember, there is evidence in the record that he was accused of pointing guns at other individuals for property crimes. The defendant admitted he responded sarcastically to one of them. On the video, he sort of sheepishly and quickly walks away after admitting he pointed a gun at someone for property crimes. The state's belief is that he pointed a gun at Mr. Zeminski for another property crime, and this dangerous behavior, pointing this loaded, powerful weapon at someone for, at the most, perhaps stoking a fire that's already been lit, would be provocation. Committing this unlawful act would be provocation for anyone to intervene and try to chase him away, whether or not it's threats have been made. And I know Your Honor takes these threats seriously, but we've also seen thousands of threats to kill that have never been acted upon. This guy,
in this case,
there's no evidence he ever caused any physical harm to anyone that night.
A different trial than anyone else.
He's on a different planet.
And frankly, even if he had threatened, he had no means to carry out his threat.
Biggie Smalls here.
So, look at the Kyle's face.
As you said, it's a great argument. There's evidence in the record, not just by video, also by testimony. And there's enough evidence to give this instruction. If the jury does not accept this argument, if we do not meet our burden, that probably is beneficial to the defense. But
you met your burden.
It should at least be argued as the evidence does support.
You met a burden to everybody,
and it goes directly in contrast to what the defendant testified to.
I think he's not going to give it.
Do you want to respond?
Judge, it's been hashed over.
Well, it's the jury's.
No.
It's the jury's case, and I think they should make the critical decisions.
Oh my God.
No. Why would you let this argument go? You were winning it. Why would you?
Why they let the defense is so awful here.
My decision will be to submit the case to the jury with the provocation instruction.
Oh my God.
No.
And argue the strength or lack of strength of the respective evidence. So I will give that instruction, and I'll give the. You didn't dispute the retreat, did you?
I don't think it's. I did. I don't think it's. If you look at the comments, it's not necessary. It says right in the comments, the committee concluded that while reference to duty to retreat is arguably unnecessary, given the potential relevance of retreat to the reasonable use of force, it's advisable to continue to publish it. It is intended to be optional in the sense that it is to be used only when the trial judge concludes that retreat is an important issue in the case, and the jury's understanding will be aided by a statement of rather than the general legal standards that apply. So I don't think that under these circumstances there's any, can't say it's unfavored, but if you look at the comments, there's no reason, in my opinion, to give it. He does retreat. There's no argument about that. But I don't think it's necessary to be given.
I can't believe they did not continue that argument.
Yeah.
It is
They're
appropriate
useless.
in large part because this was that there is no duty to retreat was mentioned in opening. I believe Attorney Trofsky referenced it in a cross-examination that the defendant had no duty to retreat. So I believe that there should be that's been put out to the jury. There should be a fuller explanation of what that means.
Wisconsin
that
does not have a stand your ground law.
They can decide and they can see if there was opportunity to retreat. We see the defendant has plenty of open space in which to retreat. He does so right after shooting Mr. Rosenbaum. And also,
this is insanity. This is insanity.
Why is it sandy? Is
the
because
whole,
this is
everybody was scattering.
This has become a bickering
and that
contest.
Dramatically changes the situation.
if you look at the FBI video where he ran to, there was absolutely no one there before the shooting.
Oh my God.
He was
How much
chased
further
there.
back can he go?
FBI
He's got a
video
rope.
does not
Even
pick
Kyle's
everybody
like,
up.
did you not
The
hear me?
Xanon video shows it clear as day. There's 100 people over there bashing on windows.
Yeah, the Zanin, I don't remember which it was. I think it was Zanin. Video to me depicted a large number of people who were engaging in violent activity. Well, property violence, but it's still they're using clubs and wrenches or whatever else.
Molotov cocktails are violence activity.
Destruction to those cars that are
Anywhere
in the area, which would have been
except for maybe some parts of Tennessee.
path of flight for the accused. And I'm wrong about that.
It's fake evidence, fake narrative.
That's what I'm saying.
You hear the 5 gunshots. You hear the first gunshot, which is Mr. Zeminski, and there's kind of a flinch of the crowd. And then you hear the 4 shots that Kyle fired.
Now let's have a look at it.
Not
I sure formed the impression when I looked at it that this is just to the south of the area where the shooting took place, and that there was a very large group of people in there who were intent on riotous activity.
I agree that the southern portion of the lot there is. The defendant testified that his first instinct was to try and head north on Sheridan, that he could not because Mr. Rosenbaum was there. But as their testimony is that he was somehow trapped or blocked in these rather loosely parked cars. And you will see, I believe in the video, that the route the defendant takes after shooting Mr. Rosenbaum.
I don't want to hear about after, because after, that's a different situation entirely.
All right, well,
Watch the video. Let's watch the video.
Oh,
God, defense, you're winning. He hates Krause. He hates him.
Everybody does.
Sitting there mutely.
Sure, you can put the sound on.
This is the time to dunk on them.
Exactly.
That's the
Get
key.
in there.
I'm glad that he said that. This is the time to dunk. You got it there.
You hit
Boom,
the
goes
guy and
dynamite.
he's staggered. Follow him.
Yeah,
And
don't just give him a
this
chance
is
to
war,
rest up, and
this is not
especially because Krause
therapeutic
can't make
jurisprudence.
arguments when he's mad.
So over here, past the hospital.
No one stood in his way. Grossly ineffective defense counsel.
What happened to all those people that are going to defend Kyle?
Most frustrating thing is they were winning that argument.
Yeah, the judge
And then they just
completely on their side.
Where are we at here? I'm about to use up all of my time on Melon. Wow.
Can you pause it, please? Or go
Why?
back 2 seconds. The defendant runs here. There's no one in that area.
Wait for the gunshots.
Well, you can't. What are you trying to say? If he runs here, I mean, that's just.
Look at all those people there. This kid's being railroaded. And his defense is as culpable as anybody else.
You know what? The only thing that Kyle could have done differently is yell out, "Help me!"
Yeah.
There needs to be a motion to well, if he loses, they need to appeal based on the improper admission of that fucking blurry photo. and the video enhancements from an expert that's not an expert.
When no one even testified that it fairly and accurately depicted anything.
Highly prejudicial.
This is absolutely. I'm telling you, don't undermine. Don't sit here and think that the.
They did preserve the objection of that photo from the expert.
Oh,
They didn't
I like
from
when
the
they say
drone
the
video.
Don't think that they're stupid. These guys are lawyers. They know what they're doing.
It seems to me that there's quite a bit of flight from that otherwise congested area after the shots are fired. So prior to the shots being fired, there were quite a crowd there. What?
Judge, I don't believe there's a crowd where the defendant ended up retreating to, but
ended up is after the shooting had occurred.
I understand. So my main reason for wanting this instruction, or our main reason, is that the defense has already stated that there is no duty to retreat. So they've already put that in evidence. I imagine they will argue it again in closings. So I believe the jury should properly be able to instruct on the law regarding retreat.
Would you want to respond?
Your Honor, he's arguing the instructions. I'll keep my mouth shut. I said he's arguing the instructions. I'll keep my mouth shut.
You saw the video, Judge. There's hundreds of people with weapons causing damage. What happens after doesn't matter because it happens after.
Yes.
And I'm trying to do this on the law, which is that it's unnecessary based on the fact that self-defense is going to be given. And the question was the use of force in the situation reasonable?
Yes.
That is contemplated by not giving 810. That's what the committee says.
My inclination is to give it, but if I find it's adequately covered in the other instructions, then I won't.
Okay.
All right. Anything else?
Judge, I don't know if there's any jury instructions. Obviously, this case, anyone can pull up any video testimony of anyone testifying. I'm just wondering if the court feels it appropriate or allowable to play portions of testimony to the jury on closings.
You mean from media sources?
Yes.
No.
Wants to play court TV.
Well, I'm not saying we want to. I'm saying we should talk about it now before anyone tries.
Well, that's a good point. I don't want to specify one.
They should play us.
Court TV is
They should play us covering
and
it.
I might add, has done
Yeah, they
a
should.
magnificent job in this trial. In staying out of my way and just keeping things going. I think. So
I think he has that question because he's trying to work on a
just,
deal.
You
remember,
could use any source that is carrying it, except
I remember, but OJ
not one
trial,
that,
right?
where
Didn't
they're commenting on it.
those
one way or
prosecutors?
another.
Judge knows about us. He knows about us.
He knows about us.
The judge is like he's like, oh yeah.
So unless there's some objection, I don't have any problem with
Anti-Semites.
that.
We're not seeking to do it. I just wanted it out there before someone tried to do it.
I'm happy to agree that we're not going to do it.
Oh, okay. Well, let's do that.
I just didn't want to be blindsided.
Let's do that. Okay, so there won't be anybody doing that. Now, but you bring up a good point. If the jury goes into deliberation and wants to look at some of this evidence, of course, one would read the law, I think, nowadays to say that any scrutiny by the jury should be in the presence of the court here in the courtroom. I very, very strongly disagree with that. I think that's antiquated. I think that that's based actually on a case I tried right here. Once again,
of course it is.
I was there. State against Maurice Pucci Franklin, and
wrote it with.
I'm not going to go into my usual dissertation on that, but that led to, I think, the Anderson case about showing videos and things. The law actually developed around recorded statements of the accused as opposed to videos of the actual events. But I think the general rule now is supposed to be that we're supposed to do all this under judicial scrutiny, and they have to ask permission, and then we have to supervise. One of the things that I find most offensive is that we've got to scrutinize it to make sure they don't play it too many times, so they don't overemphasize some aspect of the evidence. I think that's what the laws, what the cases say, and I think
that hasn't happened at all in this trial.
Us, the founders of the Constitution have juries because they don't trust the judges, and the judges have spent the last 225 years returning the compliment by telling, well, always suspecting that the juries are going to be up to no good. If this were a bench trial and like this, I watched it. How many times have I watched that video now?
You should have had a bench trial.
And you know what? I could sit and I could watch it maybe 50 more times. And in fact, the famous Boston Marathon bomber was resolved because an agent from the FBI watched the video over and over and over and over again and finally realized what nobody else had caught, which was that Mr. Tsarnaev, who's now under death sentence, well, temporarily not. We don't know what the outcome will be in the Supreme Court, but that everybody else was looking one way and he was looking the other. And it took numerous times looking at the video to solve that crime. So for me to monitor how many times the jury looks at something, and if we're a bench trial and I looked at it 100 times, and I finally decided I better not look at it anymore because I might prejudice myself, I'd get reversed because that's an absurd thing to say. So I don't want to sit here and monitor how many times they look at something. I did that once when when it was an attempted murder case of a police officer, and the jurors came down and they're told they can't even discuss it with one another, but they can't resist, and so they're saying, oh, look at that, and then I send them upstairs and they're not looking at it again. And I think that's really frightening. So I think if they want to see the exhibits, we should give them the equipment to see it and let them do what they want with it. So that's what I think. Now let me hear from you.
1,000 times.
I agree with you that is antiquated. I think this is the ideal case where giving them access or setting them up somehow with the exhibits would be great.
There's going to be a 2-week-long jury.
I saw this as a issue. I did ask people at the Department of Justice to look into it. Not a formal opinion. They indicated they believe it would be reversible error. I asked even if there was a stipulation and if the defendant agreed, and they thought it would still be reversible error under the current law, and also, and I'm not saying it would be ineffective, but they thought it would raise an ineffective assistance at counsel claim if there is a conviction. I do not want this case to be a test case on long-established law. I agree that the law is antiquated, and with the explosion of technology in the last couple decades, it needs to be changed, and perhaps we can do so legislatively. But as it stands now, the state feels that we should follow the procedures, as antiquated they may be.
Who's doing that typing? Oh, it's repeated.
I don't want them having a free-for-all up in the deliberation room.
Okay. Well, I'm not going to cram it down on this case. One day, with a short trial, this is crazy. It's just absurd. And I'm the one, I guess, who's the dinosaur on technology, but I certainly respect it more than our law does. We need to talk about the lesser included offense instructions, Mr.
Oh gosh!
Rittenhouse,
any time for lunch, yo?
The effect of these.
This is the colloquy he referenced earlier.
The charges against you, which are stated in the amended information, counts 1 through 6. The district attorney has to prove each of them beyond a reasonable doubt.
Sorry, guys.
In order to obtain a conviction on that particular count.
He came in.
And there's something called lesser included offenses, and I'm sure your lawyers have discussed it with you. But I want to make sure that you understand it, and I'm required to do that. And if the district attorney is not able to establish your guilt on the charged offense beyond a reasonable doubt, then the jury is instructed that they must acquit you, find you not guilty. If a lesser included offense is presented to the jury, any of the ones we talked about, which are less serious crimes, carrying a lesser potential sentences, if I allow those, then the jury, if they are unable to agree that you're guilty of the charged offense, will have the opportunity to consider whether you're guilty of the less serious offense and could return that as a verdict, as an alternative to instead returning.
I don't think it should be on here. I don't think you should be able to.
So you are,
lesser
by
offense.
having a lesser included offense included, you're raising the risk of conviction, although you are.
I think having it lesser.
You're avoiding the possibility that the jury will end up compromising on the more serious crime.
Yeah, I think you're right there.
And you're also decreasing the risk that you'll end up with a second trial because the jury is unable to agree. Any question about any of this so far?
No, Your Honor.
Okay. If the jury finds that none of the crimes charged in the sequence, charged or submitted, has been proved beyond a reasonable doubt, then they must acquit you. They must find you not guilty. And they cannot convict you of more than one crime on each count.
And that's how it practically works out every time.
Your lawyers have objected to some of the lesser included offenses.
Okay, so
and not others.
You can.
They have
to get to the more serious.
On some of them, they have agreed that they're appropriate. You don't have to join in that agreement if you don't want to, and you have the legal right to overrule them.
Let's listen to this.
We have
and
to
I'll
talk more
explain
about it if you decided to do that, but you would have that legal right and say, no, I want to go to trial on just the charge offenses, all or nothing, and make the decision to force the district attorney to prove each case beyond reasonable doubt. That would be your decision. Have you had enough time to talk with your lawyers about this?
I have.
Have you had enough time to think about what you're doing?
Yes, I have.
You think what you're doing is the best thing under all the circumstances?
Or nothing.
Yes.
Has anybody threatened you or pressured you or forced you in any way?
No.
Has anybody promised you anything in exchange for this?
No, they haven't.
Is your mind clear today?
Yes.
Are you feeling all right?
Yes.
Have you ever been treated for a mental or emotional disorder? Well, let me ask you this. The more important question is there any reason for me to be concerned that you have some kind of disability, mental or emotional, that would prevent you from being fully aware of what your options are and making a rational decision? Any reason I should be concerned about that?
No, Your Honor.
Okay.
If you have that ability,
any other question anybody wants to ask on this?
Would you be able to say answer?
Was, I believe, because he's in therapy. I don't think he has a mental illness or anything.
Okay.
As a result of this incident,
Okay.
he has PTSD.
Okay. And but that doesn't affect his judgment or reasoning power at all?
So,
no.
He's wagging his head. No. Okay. Anything else before I accept his decision on this?
No.
All right. So I'll accept the waiver and instruct accordingly along the lines that I've already indicated. Anything else today?
Judge, while you were doing the colloquy, I looked at my email. I got another screenshot of someone saying they know someone of the jury.
Guys,
I forwarded it along.
What?
Just for transparency reasons.
Guys, him objecting does not mean that
to the
he would
defense end of the court.
win that objection. He'd be objecting again, over the non-objections of his counsel.
Disappointed.
That does not mean he would actually win
I
those
didn't get it
objections. The
yet.
judge would likely just overrule them.
Well, wait a minute.
Why? Where's the motion for direct verdict? Where did that
Oh, yeah,
happen?
here it is.
We haven't gotten to there yet.
Is that coming?
I don't know if it's coming today or not.
Did he leave?
Yeah, I kind of
Did
heard
Biggie
the
Smalls
opposite,
leave?
and maybe I misheard it, but the way I heard it was that Kyle can actually force it if he wants to prevent lesser includeds. But maybe I misheard it.
Why wouldn't you do that?
I don't know. That's a
I
good
went all or
question.
nothing.
Because he's getting bad advice.
You either.
I mean, maybe I misheard it because I kind of zoned out in the middle
All
of
right,
it.
thank you. All right, so what's going on now?
Are we done? Is court adjourned?
Looks that way.
Are we not going to have
All right.
any more discussion? Oh, we got a new player entering the stream. Just a minute. Let me make sure he doesn't. Yeah, this looks like court is adjourned for the day.
So we're not doing the motions. That's great. That's good.
Where's
news.
the
Hey,
directed
Hoglaw's
verdict?
here.
Welcome to Hoglaw.
Yeah, that's about right
Hey.
for my timing, right? No, thanks for inviting me.
It's over,
Yeah.
Hug. We're retiring. Yeah.
Well,
I should have
thanks for coming,
invited you
everyone. Have a
earlier.
good day.
But
Well, no, it's just me tweeting out every 3
that was
seconds
the
when
day.
something happens.
That
as I
was
try to get
riveting
over
to
this
me.
cold.
Yeah, I
But,
saw you tweeting, and I was
Because you have the background, and there's so much that you don't realize. I mean, I'm going to assume that most people, that your understanding of court comes from TV. Even trials that you may have watched, you don't have this type of perspective. This is a YouTube generation thing. Never before have you seen a trial get so much attention and have so many people here, just constantly just berating and breaking this stuff down. Nick Rikita here's done a great job, by the way. I just I wish I was on his panel. So I did my own stream. But this judge is tired of this prosecution, the way they've been acting. The prosecution's acting. There seems like there's something afoot to me. There's a political question that's not being shown, and I really believe that Kyle Rittenhouse, he's on trial. It's not him that's on trial. You're on trial. Kyle's the all-American kid, doing what he thinks is right with, doing the best he can with the things he has, and they are trying to nitpick. I mean, they're going to things that don't even. I dare say they've never had a murder trial in Wisconsin that's brought up some of these issues. We've seen some very important stuff, though. One of the things is going to be with electronic evidence. I heard last night a guy, he had gone down, he's a defense lawyer, and he spent 6 days in Texas doing like a CLE type learning event on breathalyzers. We talked about how they're all digital now, and that what they do is there's a base number or something like that somehow how they set them up, and everybody just automatically just resets them to whatever the base number is or whatever. It's like a foregone thing. Like when I do a stream, I'm recording it. I put it through iTunes, not iTunes, but iMovie, and then through iMovie, I change the volume of my voice, take out any background noise if I can, and then I add a voice filter. So it's just automatic that I do this. That's how it is with DUI and doing the breathalyzers. And when I heard that, I was just so taken back. And he said, yeah, unless you know specifically what to ask for, the stuff it's submitted and everyone just goes along with it and it goes through. And he went on to say, he's like, could this throw out everybody's DUI that's ever had a breathalyzer and stuff? We'd have to see. I don't know. I was like, yeah, I think it should. I absolutely think it should. And I hate to say this, but it's the old way of doing stuff. Sometimes it is best because it's like analog. Okay, an analog, anything that's analog cannot be manipulated. I mean, it could be manipulated, but the original will not be manipulated. A digital, I can manipulate the original. I'm talking about let's say a voice recording. You put on a cassette recorder, that'd be analog. If you put on a SD card, that's digital. Well, I'm handing you the cassette. The cassette's not been manipulated. It is what it is. The SD card, before I hand it to you, can already be manipulated. I know you can do that with the cassette too, but I dare say, just for the argument, that's it's impossible to not notice that, not discover that that's been manipulated. All this stuff is really interesting.
unmanipulated evidence should be what's the factor for all states. But anyway, couldn't tell you up or down on Kyle Rittenhouse. I always think the worst. And then also, I don't know what's going on with Ahmaud Arbery trial. I think that one's gonna. I don't think justice. I think one side's gonna like what the answer is, but I don't think it's gonna be justice, no matter which side wins. So, other than that, y'all please subscribe. I appreciate it. And now I have about 10 videos to catch up on to submit. So, till later, y'all. Be good to each other. Love somebody. Call your mom. And Godspeed, right? That's all we can do. All right. Now I'm on my new thing. I got to figure out how to stop this. I may not stop this. I just realized I may not stop this because I don't know how to. So I'm using Melon, which has been great so far. I've used up all my time on Melon too. I don't know how to stop this.